I'm paying for listing of two analog of restriction losses. Pertaining to losses, restriction of sales losses from an earlier date. Similar expectations have been disposed of.
What?
We are claiming losses in your scale of pay from an earlier date. We are claiming from an retrospective date. We are giving from a perspective. Similar expectations have been disposed of, and what more expectation have been disposed of. So I'll be praying for a similar order one. Right? And maybe discuss next week.
May I bring up? Doctor is taking up the serious tomorrow with regard to completing appointment.
Probably. I don't know.
Well, I'll take tomorrow. Well, I have a similar matter which we take along with that. Oblige.
May I pay for listing for admission? Matter is for not non-patent exam.
Registry. Registry.
I beg to mention item number 26, madam, with the consent of other side, madam. I can one and time for filing an affidavit in reply to the affidavit filed by the respondent, madam. On last item 26.
You want to file the reply? Why?
Yes.
On what ground? What ground?
Madam, the respondent is filed an affidavit.
Yes. It's a simple issue. Wait. Yes.
I'm praying for accommodation item number 15.
Yes.
The elementary education is to respond to your taken their consent.
Huh?
The elementary education department is the respondent have taken their consent. Praying for
Mr. Council, what do you want out here?
the matter pertains to pay fixation. In fact, he was
Mr. Council, this petitioner has retired. What remains?
the consequences benefits that we think.
When the constitution,
Subject to the law.
we cannot adjourn this matter time and
One last application.
for what? For what?
Where the matter is sorted with
There's nothing here. 58 years in 2019. Now he's already around 65 years old. 54, 65.
one chance.
Go for what?
Just one chance. To assist your lordship better in presenting the case. Maybe on Wednesday. Subject to your lordship. Come to the case.
A general prayer has been made on behalf of Mr. Iftar. This matter pertains to the prayer made by the petitioner for pay protection with effect from 11 to 10/99. The petitioner was 58 years on 18/12/2019. And as such, as on today, he would be around 64 years. That is, he would have retired from service. This is the matter. The next. Okay. As a last, no further adjournment shall be given. The next. Huh? New matter. Go to the registry. All old matters go to the registry.
Not good method only.
24 matter is last year's matter. It's not a new matter. It might not be old, but it's not new.
But the delta
You go to the registry. Yes.
May I please, Lord? Looks item number 11, my lord. Some admission, some time may be given to file additional affidavit, my lord. If the individual need documents, my lord. That is received through RTI, my lord. We are relying on.
You are for whom?
I'm for a petitioner.
What do you want?
Some time may be given, my lord.
For what?
For filing an additional affidavit, my lord, individual need documents subsequently development, my lord. They are admission, my lord. The dispute between the respondent and petitioner, my lord, we are illegally categorized. Now, through RTI, we have received a letter from the RTI department, concerned department, my lord. They have admitted that there is no basis for categorization. So, admission is the best evidence. That document, I mean, they are
Show me those documents. You show me those documents. Let me see.
at present, I don't have, my lord, with me, my lord. My submission will be recorded. I will be some people. I will tell you for it.
A general prayer has been made on behalf of the petition on the ground that he needs to file a reply application. Reply application.
Additional affidavit.
Why additional?
But only, that is kind of, it is subsequent deadline when regarding the documents, my lord.
That's it.
As your lordship thinks.
On in view of the fact that he has been given some document to the effect that the post to which the petitioners had been appointed to were sanctioned post,
Yes, lordship.
were sanctioned post. Full stop. However, para 4 of the affidavit in opposition filed by the respondent states that the petitioners were appointed against non-existent. How much time? 1 week.
And copying with the petition, my lord, he is my remote failure of Chitsagar district, maybe 3 weeks, my lord.
If it is the chief, if it is the petitioner, you have not seen the document, then how are you going to bring it tomorrow then?
My lord, tomorrow I can.
You said that you will bring it.
Tomorrow I can get my submission will be recorded, my lord. I am
Your submission has to be backed up by some supporting document.
my lord. Nothing misleading on my part, but that is why I am repeating.
That's right. 2 weeks time is granted to file affidavit, issued affidavit. So this is the matter.
Recommend item number 36, my lord.
Yes.
Matter may become infectious.
At the 36. Yes. Okay, Mr.
A. Hussain.
A. Hussain. What do you mean in practice? It has been complied with.
Yes, my lord.
Not in practice, complied with. Submit that the contempt petition can be closed. As the petitioner has been reinstated into service, correct? And the submission made by Mr. A. Hussain, the cause for the petition, the contempt petition, can
May I please, your lordship? Maybe item number with regard to item number 16, my lord, matter may be adjourned for the day, my lord.
16.
16. No, Arguing counsel, Mr. P. K. Muni is subsequently left.
What has happened to this WPC 4021/2020? Just see that. 4021/2020. What has happened to it? We need 23. Correct. Who is appearing for the respondent? Higher education department. Yes. Affidavit, are you filing affidavit?
My lord, yes, my lord.
2020 matter. 5 years have gone. When are you filing another 5 years? Then?
Although the matter is of 2020, although the matter is 2020, my lord, this matter has come up already, I think, 4 times, my lord.
Okay, right. Mr. S. Das, also for the higher education department, is granted 3 weeks time to file affidavit of it. This is the matter of the 3 weeks, along with WPC 4021/2020. 21/20. 3 weeks.
Lordship, I want to mention item number 14.
Yes,
The Lordship, data is some info,
okay. Ms.
the doctor.
D.
Doctor,
Datta appearing on behalf of,
appellant Lordship.
no, who's there, because your name is not here in the,
Oh, now we have a
on behalf of Mr. R. Sharma, and also for the petitioner, submit that the matter has become infected. Mr. Purporting, there is petition dismissed as infected. Who is appearing for the response? Mr. SMP Kifty appears for the limited education.
May it be, Lord. My lord, 1 matter 2022, my lord, education department.
They have become,
2022 matter,
yes,
education department. Till that, they have not filed it also, it is not a,
no, you have to, tell him to go to the registry, go to the registry. Registry.
Twice, my lord. No, we have never twice. That's why I am bound to mention. My junior is high and bad.
You're
For
right,
admission,
sir.
Mano.
You're right. Mr. R.P. Photography, the press. R.P. Karma, sir. Mr. R.P. Karma, Finance Senior Counsel submit that the matter has been referred to twice to the registry for listing. He however submits that the same has not been complied with by the registry. Registry to the concerned official to appear before me in the team. As, what? No, okay, after that, after the poll, after poll. So you make a total. You give it to him, we'll see, we'll call that officer. It is correct, sir.
Dump pilot.
Huh?
They are also the helpers. So there's a dump.
Huh?
There's a dump of the
I don't know, I'll talk to him.
May I please your lordship? What should I enter mention item number 18?
18,
Matter may be taken up after due vacation.
item 18,
All of us.
no, wait, tell the senior to come.
Because the non-compliance of the order to get 22 the 11th total starts from page 20, paragraph 20. I have been declared for the post of IPC, but also the honorable court has directed to.
So there is no departmental proceeding or criminal case
So,
pending.
already those things have been inquired by the agency and deputy commissioner. I have been given a clean sheet. Still, lordship, that I may not be a good administrator. That is why, lordship, I have been removed from the post of IPC.
Right.
That has been interpreted.
Right, Mr. S.K. Das, Finance Counsel for Abu Dhabi. That in terms of the order dated 22/1/25 past date, WPC 3272 of 2020. The respondents were to examine whether the petitioner could hold the charge of principal dispute unless there was a departmental proceeding of criminal case pending against the person. The petitioner states that no decision has been taken by the response, even though there is no department proceeding or criminal case pending against it. If you notice, returnable in 4 weeks, petitioner takes steps for several notice for the respondent by registered facility within 3 days. This is the matter after 4 weeks.
But there is no criminal case.
Huh?
There is no criminal case.
There, just for understand.
Problem.
Yeah, Peter, so this is relating to drop this, sir. Earlier, okay, the petitioner will initially recognized district level committee and age of recommend, but the claim was dropped into some court case. Subsequently, when the earlier act of theft, again under 2017 act, they was again recommended, but it was again dropped. The petitioner approached before Lordship for several times. Finally, my lord, Lordship will come at page 42, my lord. Annex 8, whereby my lord, another screening committee was there. The report was forwarded by the director, whereby my name was in serial number. Serial number 21, my. No. Yes, serial number 21. Again, my lord, that name was direction was given to the authority concerned to verify these things to be by independent authority. And ultimately, Lordship will get the annexure 11 at page 53, where my lord, the petitioner name was appeared. in serial number 23, where it is specifically mentioned, but he maybe by provincial. Remark last column, my lord.
May be considered,
Maybe.
may be considered.
Maybe consider, my lord, on the basis of this, my lord, the list, already, my lord, the serial number 1, then 20, 21, and 46. There have been
1,
1,
20,
20, 21, and my lord, 46.
46.
They're the same list, my lord, their name has already been appeared. One is there, my lord, Lordship will get.
But then before you, there are quite a few also. Number 3 also, number 4 also, number 6.
Some of them have already been provincialized. So my prayer is, my lord, is, but they have to be considered. We have already been commented several times by the.
Depending if there is some vacancy.
My lord, the post, my lord, they are saying the earlier occasion, they one post is vacant in my case, my lord. And the all the cases
Yes,
also
madam, what
the
did you-
vacancy there. And this is, my lord, the lordship, my lord, in lordship order, where it is specifically stated that something has been dropped, my lord, illegally, not by the, because of any other thing. Suppose, my lord, in court case or another, my lord, other reason. The same benefit may be given to the retrospective effect in the 2011 act, my lord. There is some saving clause was there in the effect. So my prayer is, my lord, let them come with that instruction, my lord, whether one can get the provincialized or not in the other way for the notice. We go take some time.
Let the notice may go. in this way.
Okay, right.
My lord, the lordship will see my annexure 6 at my page 40, my lord. Where it is specifically stated as speaking order, post is vacant, my lord.
Page 40.
40, my lord. The lordship will get in third para, my lord. In this context, it is mentioned here is that the two numbers of the post of the graduate research is lying vacant in Unandaguru High Madrasa, now high school, due to the retirement of the Nurul Haq, assistant teacher, art, along with the lying vacant.
And you are what teacher? What teacher are you?
While at the assistant teacher art. Well, better, well, they should come with all instruction. I pay, well, unnecessary, well, better should not be kept in pending. Because if I am entitled, they give a specific, well, come with all specific instructions, so that might be disposed of, well.
So if you think.
Because, well, we are already.
This may go, your lordship, because there are similar matters are your lordship today matter has been listed. So your lordship, a notice may go along with those matter also, your lordship.
When are you retiring?
But within 2 3 years, I will be retirement. Another
Still have
also
time, your lordship.
Still time,
3
still time.
years.
minor one minor income and it is 52, he already retired. Now, not before your lordship, but they in the same list.
Okay, right. Heard Mr. P. Martha, then also for the petitioner who submit that in terms of the annexure, in terms of annexure A to the letter dated 23/3/2024 issued by the Director of Secondary Education, SAM, wherein the petitioner is listed as, no, in terms of the annexure A, where the petitioner's name is in serial number 23. In terms of annexure A to the letter dated so issued by so where the petitioner's name is as annexure 23. The petitioner can be considered for provincialized
Provincial.
in terms of the 2017. However, the said letter has not been acted upon till date. In respect of the petitioner, those serial numbers 1/20, 21, and 46 have been provisional. You obtain instructions when
Your lordship, notice may go,
Why?
your lordship. Your lordship, because the DSC committee provincialization matter, your lordship, under
So?
Act 2011.
It's already, it has recommended by the director of the.
So whether-
they issue notice returnable in 4 weeks. Petitioner takes, means, he does accept notice on behalf of
1 to 3.
1 to
second
3.
benefit.
Mr. Please, Sakia. Except notice for the respondent. What is the matter after 4 weeks? To enable the respondents to obtain instructions as to why the petitioner's service has not been returned.
Extra copy means
Extra copies of the writ petition be served to the.
And it is
for the
similar
response and the
method.
person.
similar method.
Out there?
3, 5, and 7 micro.
Okay.
Only matter the position of the numbers of the.
Yes, so out here, in item three, what is the position?
My
of the
position is
pet-
54.
54. Then in item,
And then item 7, 5 micro
Item
is
five?
61. 61.
61, and item 7,
7 minus 51 minus.
51.
Plus. I think.
Appear 7 to
Not in this case, I have got it. Take me down.
Huh?
I have got some mistake in the first title. So,
What do you want in your writ petition?
petition will not compassionate appointment.
Compassion appointment?
Because
Or
it-
compassion appointment?
Mira. In fact, will
And when did your father die?
not that. 18/11/2023.
18/11/23.
2020.
On 18/11/23,
Mila.
what was the OM applicable? What was the OM applicable? You see that compassion appointment, OM, has been superseded by the 2017 compassionate family. The compassionate family pension.
Pension.
Scheme. So you're not entitled to compassionate appointment. No case. End of the matter. You can claim compassionate family pension. That's all. So what are you going to do? I'm dismissing or you're withdrawing? Okay, I'll dismiss. Right. Third, Mr.
I will tell.
Third, Mr.
Yeah, Ali.
A. Ali. Third counsel for the petitioner who submits that the petitioner's father died on 18/11/23. When the OM dated, what is that OM dated? What is that OM? 2017 OM? When the OM dated, 2017 was in operation. Comma, wherein it provides that the family member of the deceased government servant would be provided compassionate family pension. Mr. R. Ali accordingly submits that.
Yeah, Ali.
A. Ali accordingly submits that he may be allowed to withdraw the writ petition and make a claim for compassionate family pension. As per the OM dated, that 2017 OM. What was the date? 147. And this impugned one is of 2024, correct? Huh? So he's withdrawing. Huh? 18/9/24, correct. So he'll be, he can be considered for the compassionate family pension. So whose name should I reflect for the, yeah. No, out here as a council. He's withdrawing. Huh? Elementary education, who's elementary? I'll put it in Mr. P.K. Bora, appears for the elementary education.
May I please, Lordship? Let this matter, pertaining to payment of arrears salary matter. Although it is a long pending matter, Lordship, at this stage, my lord, my humble prayer before your Lordship is that Lordship will kindly issue a notice, let them clarify them. This is my legitimate expectation that
Yes,
we had not
madam.
drawn any arrears salary matter for that particular
maybe
period.
for 1996 to 2006.
1996,
Only
correct,
notice
from
which Lordship will kindly
1996.
issue. Otherwise, my lord, the issue is gonna, my lord, the expectation is my lord,
Huh?
very legitimate, my lord. My claim is also my lord, very lawful claim. Yes, the issue is my lord, long back, but it should have been filed much earlier occasion, that I admit, my lord. But at this stage, Lordship will kindly issue a notice. That is my humble prayer before.
You have come too late in the day.
Yes, that I admit.
Yes, that's
I apologize for that. My lord will kindly issue notice bill.
too late in the day, Mr.
That I admit.
1996, now it's got 2025.
Till 2023.
How many years? 30 years. Oh my God.
My lord, one
Mr.
replacement
Z.
appointment.
Are you Mr.?
Z. Ahmad.
That's possible. The petition has been working as a teacher. And he retired on
Not retirement.
Not
Not
retired.
working.
working.
Yes, bill.
And
As assistant teacher. In the respective school. Annexure 5 and 6 minute we clarify.
whatever I said. Who submits that the petitioner was irregular, he was appointed as a teacher. How many writ petitioners are here?
2 writ petitioners.
Huh?
Only 2 million.
The petitioners were appointed as teachers during 1991 to 1996.
Period.
What do you mean? When were they appointed?
But they were appointed, my lord, as per the regulation order, my lord. There is a order
No,
of
no.
regulation.
So they are appointed in
I have an
1991
91.
or to 96. Which one?
91 minute. 91 minute. This post has been created. Annexure 1 and 2
Appointed
minute.
1991.
Yes.
During 1991 to 1996. That's what they said. Were irregularly appointed. That's what has been said. Irregularly appointed. How you have been appointed, we don't know. You appointed in which school?
But I was appointed earlier in the very initial stage, my lord. The petitioner number 1 was appointed.
You have not said
with
anything.
name. I have stated, my lord. Annexure 1 will reflect, my lord.
In which
It
school?
is very clear.
Ah,
Annexure 1, page 12, my lord.
Eligible, my lord.
but you should know when you were appointed. You are saying that you are appointed between 91 to 96.
No, my lord, this is the order of regulation, my lord. As per the
Correct.
partic-
I want to know from you, when were you appointed?
My lord, I was appointed in the year 1991. my lord. It has been reflected also,
Right.
my lord. Yes.
Thank you.
Thereafter, their services were regularized as assistant teachers by order dated
7 2 to
7 to 2000.
Right.
Good stuff. In Udmari ME School. Udmari ME School and Dakin Guri Guri ME. You are 50 years in March 2025. Correct.
my lord.
Yeah, 50 years in March 2025. That means in March 2020, you were 25 years old. In 1991, you would have been minus 9 years, you would have been 16 years.
Yes. After
So
passing,
you joined as a teacher when you were 16 years.
well, after I have informed her, I have inquired about it. Then after passing matriculation, they had joined into the service immediately.
Without being 18 years of age. Prior to 18, you joined. Good stuff. What have I said? The petitioner's case is that he has not been paid his arrear salary. They have not been paid their arrear salary with effect from 1/6/1990 to 7/1/2023. 2006. Next up, Ms. S. Sutia appears for the Ms. S. Sutia and Ms. R. M. Barua appear for the respondent. Appear for the respondent and submit that this petition suffers from laches and delays and accordingly dismissed. I have heard the counsel for the a perusal of this petition shows that there is no document to show when the petitioners were appointed and to which schools they were appointed and by whom they were appointed. There is also nothing to show as to what pay was to be given to them at the time of their appointment. Further, the petitioners having apparently worked in different schools, the cause of action of both the petitioners are different, appears to be different. The above being said, the petitioner number one has stated in his affidavit dated 10/3/2025 that he was 50 years of age. If the petitioner number one had been appointed as a teacher in 1991, then he would have been 16 years of age at the time of his appointment as a teacher. The writ petition is woefully WOE, woefully bereft of particulars and documents in support of the petitioner's case. Besides the above, in the case of Arendra Chandranath versus state of Assam, and in the case of no, before that, first in the case of Dash and in the case of the Supreme Court and the division bench of this court has held that there cannot be a claim of arrear salary beyond 3 years from the date of the filing of the writ petition. In the present case, the petitioner has made a claim for payment of arrear salary for a period starting from period from 30 years prior to the date of filing of the writ petition. In view of the enormous decay and laches in filing the writ petition, this court is not inclined. And keeping in view the judgments of the Supreme Court and this court is not inclined allow the writ petition. Are inclined to exercise discretion in the present case. The writ petition is accordingly dismissed. I'm trying to bring the instruction. Huh?
Last provision notice directed being factor otherwise.
Pension not finalized. So what? No instructions given to
I
you.
have not received it.
Okay, we'll tell him to appear.
Fine.
Right. The heard Mr.
Right, yeah.
R.I. Buya, learned counsel for the petition. And Mr. P.K. Bora, learned counsel for elementary education. Part. The petitioner has prayed for washing the letter dated 4/5/2019 issued by the respondent number 4 in respect of wrong fixation of the petitioner's salary with effect from 1/1/1989 and also issue direction for finalization of his pension and other retirement benefits. This court, by orders dated 10/3/25 and 20/03/25, has directed the council for the elementary education department to obtain necessary instructions with regard to the same. Mr. P.K. Bora subject that no instructions have been forthcoming from the district elementary education officer Hailakandi. In view of the above, the district elementary education officer Hailakandi is directed to appear virtually on Friday at 10:30 a.m. to explain as to why the pension proposal of the petitioner has not been made till date. So, sir, if the same has been made, the status of the pension proposal. This is the matter of Mr. P.K. Bora can inform the concerned officer to appear virtually, or else more stringent orders may have to be passed.
Obliged.
Yeah, people look because they kindly pass over the time.
I cannot see it. Kindly. No, whatever it is, I cannot see any paper. Yeah, like that. Right. The petitioner was supposed to appear virtually. Right. Okay, right. No one appears for the petitioner. The court master has stated that though a link has been sent to the petitioner's counsel to appear virtually as per the request made by the petitioner's counsel, no one has joined. According, this is the matter after 3 weeks. But to let's the matter in the next week. Next. Yes.
I learned the in order is just by the just 55. Whereby method, the district commissioner method without any CPT or authority had issued the in order method on 10/3/2025 method
whereby my lord had directed the inspector of school, my lord, take over the charge of a private, totally private institution, my lord, here for it, which is totally impermissible in law. Because district officer cannot, without any judicial authority, my lord, can invoke his jurisdiction
Yes,
and private
who's for the district commissioner?
Okay, we represent the district. Okay.
You see, the question is, does the DC have the power to issue an order to the inspector of schools to take over charge of principal?
in a private college.
Huh?
In a private college.
Whether it's a private college or a government
But
college,
even
I
the
want to know. Yes, Mr. Deary.
Uh,
No idea.
under what provision he has taken, your worship? So that means.
You see,
there is no benefit.
there has to be to do certain things, you've got to have power.
Yes, sir.
That power has to be, the base has to be there.
Yeah.
What is the basis for a DC to issue an order allowing the inspector of school to be the in charge headmaster of a school? Can a DC say that, can a DC tell an inspector of school to take over charge of a school? Who has the authority? Is it the education department or is it the DC? Is it the chief engineer of PWD? Who has got the power?
That I have to.
You have no idea. So PWD chief engineer might have the power also.
Uh,
Yes, Mr. Well, yeah, have you got any idea?
And not actually, this institute are
Huh?
recognized by NCT.
Huh?
NCT.
So
So NCT has the power, actually.
if
But
NCT has the power, then the DC has got no power.
My lord, I have to submit. Is there is some corruption charges and anomalies.
I'm not on that. There might be corruption galore.
Because of that, you see, as a deputy commissioner, has the power to monitoring the local body.
Show me the
No.
power. Show me the power.
My lord,
Show me the power.
he has, he has issued that letter, 65. He has said that there is
55. You mean 55, not 65.
Yes, 55, he has written specifically that from under transformation and development branch.
Huh?
This letter has been issued, this order particular. Transformation and development branch is written in second para, as such the inspector is first para in view of the letter from parent body of Project Samata Education Society. Request
How?
Project Samata Education Society is the sponsoring body who has got recognition from NCTE. NCTE always takes performance report, asks for whatever financial development going on from the parent body, not from the governing body of the Samata.
I'm not on that, Mr. Counsel. My question is very simple. Very simple. If you don't understand, don't answer it. The simple question is, can a deputy commissioner direct an inspector of school to be a in charge principal? Can he do that? Inspector is
cannot- he
inspector
can-
of a school.
He cannot.
Whether it's a government school or whether it's a
No.
private school, I'm
I
not
admit,
putting that also.
I admit.
It's only with regard to a school. That's the Deputy Commissioner has the power.
I agree, my lord, he cannot actually directly
Then-
involve, he can give report.
Then
But in this case, my lord, let me submit some few lines. my lord. In this case, this particular governing body first approached the deputy commissioner.
yeah,
Under the delegation of power, circle officer has, in the previous occasion, both the writ petitions are withdrawn, has the, without no power, constituted this governing body
I'm not on that. That is
because of.
that is not an issue here. That is not an issue in this writ petition.
But my lord, there is lots of financial irregularities are going on.
You take whatever action. I'm only on that aspect. But there is another aspect, Mr. Counselor.
My lord.
He, Deputy Commissioner has got no power. But you are 66 years.
My lord, that is extended, my lord.
Huh?
My lord,
No, where is the extension? Where is the extension?
Amended, my lord.
Where is the amendment?
Amended,
Let me
my
see.
lord, kindly come to page 66, my lord.
Page 66.
My lord,
Yes,
basic kindly paragraph 40, my lord. Here, my lord,
paragraph
four, my lord, 4B,
4P.
my lord.
Ah.
In sub paragraph 2 of the notice, note 2, item number 1 of for the figure. What
In
65
sub paragraph 2, in note to item 1.
years, yes, my lord.
For the word 65, where is that?
70 years, my lord. Now,
Page? Where is this sub para 2? The note 2?
PS 58.
Huh?
PS 58.
Page 58. In
No,
appendix
that-
4 to the said regulation. Where is appendix 4?
That note, my lord. Yes, it note.
No.
In sub paragraph 2,
Ah.
in the note to item 1, for the figure, the word.
In the note
The word 70
to
years.
item 1.
Yes, sir.
Item 1. Where is item 1? Note to item 1. Where is that word? 65 years.
Yes, last line,
No.
65 years.
Okay. In the note, in sub paragraph 2.
Yes.
Where is sub paragraph 2? Sub paragraph 2
Four
there.
to
Sub
qualification.
paragraph 2, note to item 1. Okay. Okay. Okay, right.
my lord, here I like to submit something. My lord, this, after that 2021, another notification was passed. In here, 5.4, para, terms and condition of service of staff. The terms and condition of service of teaching and non-teaching staff, including selection procedure, pay, band, or scale age, or of superannuation and other benefits shall be as per the policy of the central government or state government or affiliating body or university.
Okay.
So, whatever 70 years term
That's
has
gone.
been included,
Ah.
after the 2021, this comes
2021.
21 notification. So, 65 years,
That is not applicable. That is clearly stated in page 70.
this is notification after that.
That-
National Council.
Let
for
me see
Teachers-
that. Let me see.
NCT will clarify, madam. NCT, they are, madam. What happened, madam, if someone is, someone service is professionalized or regularized prior to 2014 notification, that will, he will govern by the notification prior to 14 only, not subsequent. And it is also there, madam, page 70, madam. Guwahati University is clear, it will clarify.
So, And where does it say that the policy of the central government or state government is 60 years or 55 years? Where does it say that?
Not say that, but policy of
As
the
per
state
the-
government must be followed, but policy of the state government or central government
Has
nowhere
to be
written
followed.
70.
Correct, as per the NCT.
Why not?
This is also done as per the NCT.
Why not? I have to submit another aspect.
Yes.
This arrangement of not getting qualified person has to be for a period of 1 year at a time, not that for 5 years. He has no further extension, but here in para 13, specifically para 13, written date
Para 13
13.
of
page
this book.
15.
Of this book.
No. There it
Read petition. Para 13.
para 13, page 15.
Para 13, page 15. Yes.
Here they have claimed that on 16/9/2022, his service has been extended. Why not? Date maybe since 16/9/22.
Yes.
Thereafter, on 22/9, he has given resignation letter. Principal in charge written resignation letter. He knows the consequences of law. He is a well qualified person.
Tarun Chandra Bhagavati.
That is governing body has filed this petition,
According to what you have filed.
and this is the principal has given the resignation letter.
My lord, challenging the principal, my lord, they had filed 2 repetition, my lord.
That has been
Huh?
withdrawn.
They had filed earlier 2 repetitions challenging the appointment of the principal, my lord. But they had to withdraw subsequently, my lord. They had withdrawn all these repetitions, my lord. All the repetitions.
I have first, when I have submitted
What's their
first,
intention, my lord? There's nothing, my lord.
My
All these
intention is clear.
my lord, they are running
My
after the
intention is
bank
clear, my
account,
lord.
Nothing. They are only
My-
after the money of the.
My intention is clear, my lord. When I have first submitted, I
So what do you want?
No, my lord. My lord, I have already published the, my lord, advertisement for fulfilling the code.
at
Principal, my
present, my lord, this is
Yes.
25. All
Yes.
5 years governing
My lord,
body is keeping
And
silent.
the extent of the service of the principal, my lord, extended by the parent body himself, my lord. If your lordship come to page 72, my lord, as well as 71, my lord. The extension, my lord. It is the by the parent body.
Who is to appoint the principal?
Governing body.
Then you appoint. That's
Yeah.
all.
I love my appointment, my lord. Definitely, my lord. There is the advertisement.
You don't have to appoint the same person.
No,
Just
I am
appoint-
not bound. I am not bound to pay upon the same person. There is a fresh agreement there, my lord. Due to condition of the repetition, my lord, and since there was the equitous operating, my lord. That's why, my lord, there was not could not be pain effect. After the withdrawal of the repetition by the parent body, my lord, the governing body has issued the advertisement, my lord. Where's the advertisement? And it is there.
But after this appointment, he
Now,
has
my lord,
resigned.
there
Huh?
nothing.
After appointing on 16/9/2022, that learned principal has resigned, and he
Ah.
said he medically, mentally not fit.
Okay, he's resigned.
Even he,
So he
Now
has
who-
refused. Now they are forcing to
I will
put
release
him
him.
in this position.
Forcing whom?
Governing body has filed this case only to keep this principal illegally in that post, but he has himself refused.
No, that person cannot be that person cannot be a principal.
That
No,
is
that-
the
that-
main.
No,
main
that
issue
is nothing, man.
Where is the advertisement that you have issued?
No, madam, that is totally false, madam. Here, madam, kindly see the advertisement, madam. They are saying, madam, page 69, madam.
When was this issued?
It was issued, madam, on after withdrawal of the petition, madam, they are issued. It was issued.
2/4/2024. Okay, you let him hold the charge till you
Yes,
make a regular
That
appointment.
is no.
Make it.
I am very much agree.
Yeah, DC has got no role to play. What is
But my lord, NCT has been made party. If he is giving charge and for holding the post, they may not follow the rules because they have vested interest. Lots of anomalies are there and lots of allegations are there. some parent.
There is no stay of this. Is there any stay of the advertisement?
No, no, no.
Then carry on. In the meantime, let him hold the charge. The inspector of school.
No, my lord. Why, my lord? There is existing, my lord. It's a-
Who is the principal?
My lord, keep a lot.
Who is the principal right now?
Well, don't understand it.
He is 66 years old. He cannot be principal.
But the amendment is there, my lord.
No, no. After the amendment,
No, my lord.
there is a 2000,
Lordship has not got the,
2021
no, my lord.
amendment
Yeah,
regulation.
well, kindly come to page 70, my lord. That is the university, there is a separate amendment is there, my lord.
Page 70.
Yes, my
70.
lord.
Yes.
See, my lord. Yeah, this is the issue by the Guwahati University.
Yes. Let us see.
Can we see last paragraph, my lord. Moreover, principal, teacher and other staff members who joined prior to the implementation of the NCT regulation 2014, fulfilling the norms of the NCT regulation are considered to be eligible. Prior to 2014, well, they will continue, my lord.
Considered to be eligible
They
provided.
will
the-
continue.
What do you mean clean cutting? You
Yes.
see, when the
But there is
NCT
a limit, my lord, let them NCT appraise, my lord. Because NCT is there, my lord.
who is for the NCT? Yes.
They cannot make.
Yes.
My lord, first of all, they have already, the institutes have already issued the advertisement. That is on last date is
What is the age limit for a principal? When should a principal retire?
In fact, my lord, the repetition have annexed the regulations of 2010, my lord, but 2014 regulation is come into force, my lord. And as per 2014 regulation, my lord, the age limit is 66 years.
What about the 2021 regulation? What about this 2021 regulation? Yes, give this back.
This is the university certificate. This is the certificate of the affiliated university, my lord. My basic question, my lord, whether this is the university power of law. My lord, in this certificate, my lord, it was issued by the Guwahati University.
Yes.
My lord, there is a no policy.
Huh?
So there is a no age limit, and that will be as per central government and or state government.
Yes, as per central government rules,
That is 60 years.
60 years
I
or 55.
will have to probably change the advertisement is already there, my lord.
Huh?
I will act on the advertisement, my lord. I will
Let
act on
them,
the
let them complete.
You act on the
I
advertisement. There's
I will
no.
complete the process, my lord.
You
The
complete the-
governing body will complete the process and
Till then, the principal cannot be allowed, and the principal has not come to this court also. You have come.
yes, sir.
He is not agreed. Why should you be bothered?
But I am the governing body, my lord.
He doesn't want.
My lord, she kindly can there is so many things, my lord. The between order, my lord, which was issued by the commissioner.
Who will there be an in charge principal without in charge principal?
Then,
But
my lord,
we cannot allow the petition.
no, my
Yes,
lord.
perfect.
Yes, my lord. But
We cannot allow the principal. No.
my lord, kindly take this one thing, my lord. Whether my main question is whether
My lord,
the
may I
district commissioner has
submit,
the authority,
my
my lord.
humble submission is that if at all DC has no power, this current principal.
Principal cannot be.
Cannot be allowed, then NCT may be given direction
The senior
to.
most, senior most faculty.
No, they can appoint.
Yes, yes. Senior must take a-
You can appoint.
My lord, in fact, in the input water, my lord, it was also there, my lord. That until and unless, my lord.
You can appoint even a retired professor or head, anyone, on contract basis, provided that he is not 65 years old, or he's not as per the rules. Yes, Mr. Nayak, you can help. Who is that? Okay.
Okay. Apparent, please.
Ah,
not for full time.
okay.
However, the better company
Ah,
and the package like that. Similar companies that was
ah,
he interpreted in the 40
ah.
this is it is temporary measure not. That's the effect of because of that bit of the problem. And feel the new pin for not offered. So substitute very so let the inspector to substitute and insert and feel the moment.
Now just tell me one thing. What is the power of deputy commissioner to issue a order for appointment of an in-charge principal? Under what provision of law?
So right now, I if as a deputy commissioner not
No. I don't know. I don't. No. There has to be, you see, there has to be a source of power. Supreme Court has given many judgments that unless there is a source of power which has to be exercised, it cannot be done.
This is judgment of Honorable High Court also.
No, that's what I've asked him. He doesn't know.
tomorrow, day after tomorrow, we'll take some instruction or further for that was only the
Last paragraph, my lord.
That's better.
37 paragraph.
Yes. No, there's a different thing.
But private matter, my lord, the district commissioner cannot, my lord, without statutory provision. Yeah, my lord.
Yes. Can you get instructions by tomorrow? I'll give you one chance only because of course, and you have to appoint somebody else.
Yes, my lord, definitely. Oh, what, my lord, one point I have kept. The last Friday, this matter was listed, my lord. Last Friday, my lord, this matter was listed. Saturday, my lord, the governing body had some meeting, my lord. What happened, my lord, district commissioner, my lord, he had a circle officer, man. To record the video of the, my lord, meeting.
It's okay. Yes, can you get instructions by tomorrow?
I shall try.
No, we are going to dispose of the matter.
What I think. Let him furnish an extra choice.
You see, it's only one small question you have got to ask the deputy commissioner. Under what provision of law has he issued the order appointing the inspector of school as in charge? That's all.
Yes.
What is his
yes, sir.
authority? What is the base? What is the basis for issuing that order? That's all. No need of any writ petition and all. That's that.
Merely saying he has received a complaint, so he has acted upon that. And we are, as per your lordship, that under what provision of authority he has acted upon, which source gives him the power to do so. So I will try to.
Only that, nothing else.
But receiving a complaint, he has to act upon that.
He can act within his powers. He cannot solve the entire problems of the world. You see, he cannot solve a problem in America. Why? He has got no authority to do that. He cannot solve the problem in Maharashtra because he has got no authority to do that. He has got power within his own jurisdiction based on something. You see, otherwise, so he'll say that, hey, I've got Silchar, there's something going on. Although I might be district commissioner here, I'll solve the Silchar problem. He cannot do that. There has to be a basis.
May come on Wednesday, Thursday.
Okay.
But my
Wednesday.
very bad.
Right.
Okay, that.
The Mr. B. Dury, learned counsel for the district commissioner, shall obtain instructions as to the source of power / basis for which the impugned order was passed at page 55 of the report. That's all.
Can I have the copy of the order?
5 to 10. If it is fixed on Wednesday, or your lordship may provide a
Shall I,
reasonable time.
huh?
Reasonable time, because I have to send it there to receive it.
Mr. Counsel, it's a very small thing.
Okay.
It's a one line. What is it?
Okay.
You don't, right.
Okay.
In the event Mr. Brigadier is unable to obtain any instructions on the next day, the matter will be decided on the basis of the material on the file.
Fixing on.
I've got the judgment. Should I give you the judgment also? Union of India versus Tulsi Ram Patel. 1985 or 88 or something like that. Wednesday.
Potential. I'm. May matter not be matter. Tendency of the.
This you put it back. Yeah.
In the meantime, when the governing body may be given a liberty matter to take that
To what?
we appointed some new people.
We're going to decide the entire matter day after
Fine,
tomorrow. That's the only issue.
Fine.
This you can. No, that you don't do. The other one. That you can. This is given by this guy. If you want, you can take it back. I'm being item 49. Item? 39. Yes.
Yes, madam. Yeah, please, the impugned order is in page 50, madam.
Huh?
Page 50, impugned order.
15. 1-5.
50, madam.
Huh?
50.
Yes.
I think the impugned order, madam, my accommodation order was cancelled, madam. By the respondent number 1.
Yes, I know. So what do you want?
This I challenge this.
Huh? You are challenging this order
Yes, madam.
at page 50, correct?
Page 50.
Yes. But then this order has not solved the issue. Why don't you go to the tribunal or you go to the civil court
Should that
to
direction
know,
is given-
because both of you are claiming to be of the same name.
that direction is
Moinul,
given,
you are
madam.
both claiming to be MOINUL, correct?
Yes, madam. Earlier,
So the issue is that the appointment order
yes,
of 22 is in the name of MOI.
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 Okay.
So you are saying that you are MOI, except
MOI.
for there is a mistake in one certificate of yours.
Yeah.
Correct? Which one? Class 10.
My original appointment, my lord, in the issued in the year, my lord, 1995. Also same, my lord. MOI, my lord.
But then there was a MOY also.
Yes, my
Which
lord.
one?
But my lord,
MOY is which one? The MOY is which one? Which certificate is MOY?
MOY, my lord, my all my lord, academic and the other.
The academic is MOY or I?
MOY, my lord.
Y, all Y.
All Y, my lord. Only appointment letter is MOI, my lord.
So
The
that
year 1995 also my lord, MOI, my lord. Can you see that? Annexure 1, my lord.
yes. Who is for the private respondent is here? No. So I think you should go to the. So according to you, all your certificates are MOY.
MOI, my.
Are you sure?
Yes, my lord.
Where? Show me your certificate.
No, the next, my lord,
Huh? You have not annexed.
next, my lord, but I got the copy.
They go to the civil court or to the tribunal? What to do? The issue here is basically MOI or MOY. The appointment order is MOI. Now, who is MOI? Either this person or the respondent, private respondent. And according to you, all their certificates are MOI.
Yes.
Then you lose out. Where is this case?
Before 2024, my lord, I never objected by the authority, my lord. They are allowing to continue me, my lord.
No, but you are saying that your name is MOI. Appointment order is MOI.
MOI, my lord.
Then
In the 1995 also MOI, my lord.
Huh?
In the 1995, my original appointment letter, also MOI, my lord.
correct, everything is MOI. Problem is now we have got to know who is actually MOI and who is MOI. That is why the respondent has said that you are not MOI, you are MOI. So why should you be appointed? He said that I should be appointed.
The private respondents are from the different school, my lord.
Maybe I do not know whether it is MOI. MOI or MOI. Yes, okay, right. I think we'll go to the education tribunal. These are disputed questions of
Yes, my lord. That I recommend.
heard Mr.
HL letter.
H.A. Laskar, learned counsel for the petitioner. Also heard Ms. S. Tutia, learned counsel for
1 to 5.
respondent number 1 to 5. No one appears for the respondent number 6. As no notice has been issued.
6 and 7.
6 and 7 as no notice has been issued. Still there. The matter pertains to whether the petitioner or the respondent number 7 is the person to whom the appointment / accommodation order dated 23/09/22 had been issued. 2. Full stop. In the appointment / accommodation order dated 23/9/2022, the appointee's name has been recorded as MOI NUL HAQUE LASKR. Both the petitioner and the respondent number 6 claim to be the appointee in terms of the appointment / accommodation order dated 23/9/2022. The impugned order dated 30/10/2020 issued by the respondent number 1 states that the appointment / accommodation letter dated 23/9/2022 is not related to either the petitioner or the respondent number 7. As such, no, the same was accordingly cancelled. As such, The petitioner has put to challenge the impugned order dated 30/10/2024. On the ground that all the educational certificate of the petitioner bear the name MOYNUL, correct?
Yes, ma'am.
Hawk Lasker. So that straight away you go, you lose out. Where's your case? Or are you trying to take this court to a different garden path so that you can file an appeal? I hope the facts. Where is your certificate?
Exactly.
Let me see. Okay, Moinul. Okay. However, the accommodation slash no, however the appointment slash accommodation letter dated 23/9/22 though no however though the appointment slash the letter names the appointee as MOI, huh? The petitioner is the one to whom the said letter relates to. Out here is different, Mr. Counsel. Out here is HOQUE. Out here is HAQUE. Haq.
HOQU.
Correct. So again, you've got no case. You are saying that your name is MOY anywhere. The letter, the appointee letter, appointment letter is MOI anywhere, not you. And you say Haq HAQUE. Then what is your case? Okay. That's all. Next. Then you write somewhere. Huh? I have seen the photocopies of the documents submitted by the petitioner's counsel, comma, which is the admit card for participating in the board of secondary education, no, for taking part in the Assam High Madrasa examination 1983. Okay, write that one, huh? Then number 2, mark sheet of the board of secondary education, comma, Assam. Number 3, this is what unique identification authority. This is
This is the Aadhaar card.
Aadhaar card. Aadhaar card. Number 4, certificate, no, province certificate dated 21/9/83 issued by the Karimganj High Madrasa. Number 5, identity card issued by the Office of the District Elementary Education Office. Next card. All the 5 documents submitted by the petitioner shows his name to be MOYNUL HOQUE Laskar. No case. I'm sending you to, you can go if you want, you can go to education private
Yes, ma'am. Educational guidelines.
if you want. I'm dismissing your case, huh? dismissed, okay? You can, I'll write there, liberty is given to you to go there. if you- Okay, I'll make this part of a record, better I think. The, the above documents are also made a part of the record and marked as annexed here. Which one is what? Admit card, no? Admit card is annexure X1, X1 to X5. Okay. X2 is what? Mark sheet, no? Number 3 is other. X3. Next. Annexure X4. And annexure X.
Maybe look. Of course, getting out the order. Maybe look, the document pick up the matters immediately after.
No, no, I'll take it up now. No, 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 I'll take it up now. No,
My
no,
lord,
no,
it-
no,
it-
no,
yeah,
I'll take it up now.
Or admission hearing, then.
No, no, it's a small issue. It's a very small issue.
Ah.
It's a very small, it has been adjourned time and again.
Yes,
No, I am not taking time. I have taken time.
no, my lord, it is a very
No,
urgent matter.
huh?
The interim order was passed on misrepresentation of fact, my lord. There
Yes,
is a
yes,
complete
yes.
misrepresentation of fact. my lord.
So you see, now there was an advertisement,
Yes. there
Correct.
was a- Yes,
advertisement of 8/11/22.
my lord.
That is, where, let me see in the writ petition.
Yes. It is there in the writ petition,
Page,
yes. And page 24,
page 24.
yes. And he has challenged this advertisement.
Here challenges that this is for filling up the
He has
post of,
challenged that, he
no,
was a
filling up the post of assistant professor.
my lord.
Is it?
On temporary basis.
Yes. So he's challenging this on what ground?
On the ground that because he was there in the post, so there should not be any regularization.
Okay, there should not be any filling up
Yes.
because he's in the
Yes.
post.
But
So
the
this advertisement is for regular appointment or
regular appointment, my lord.
page 24? Yes. Now, so he was there in this post since when?
2016.
2016. So that he's the writ petitioner, correct?
Yes.
Just a minute. Okay.
There
So now he's challenging that on the ground that he should be regularized,
my lord.
correct?
Yes.
Now, did he take part in the selection process?
Yes. In that subsequently, in the selection process, he appeared.
In pursuant to this advertisement,
Yes, in pursuance of the advertisement.
pursuant to this advertisement
My lord.
dated
Yes.
8/11/22.
Yes.
That's all. That's the case.
He appeared and he was unsuccessful. I was successful, my lord. I have annexed the selection committee's order, my lord, at annexure 3 of my petition.
In the history of your
My petition is page 12, my lord.
of your is it I or the main writ petition?
It's a stay vacating application. I 393897, page 12,
So your name is?
number 1, Buddhadev Lahiri. And
His name was, yes,
So your pass is 53.
yes.
His name
His name is 5, serial number 5. Rangjalu
Basamatari.
Basamatari.
So he got 33.8.
Yes. And my lord, thereafter, he obtained the order by making the Guwahati University to be the party here. But I am appearing in Dibrugarh University. And that Dibrugarh University was not made the party here.
Dibrugarh University was the one who conducted the selection process or what? No.
Dibrugarh- I was selected under Dibrugarh University.
Okay, you are selected for the post in Dibrugarh University.
University.
He is working in Dibrugarh University
Yes.
also, in that department.
Yes.
This is what department?
That is Bodo.
Huh?
Bodo language.
So,
Silapathar Bodo language. And the university college name is Purvanchal College, Silapathar under Dibrugarh University.
it does not say which university. Where is the university name?
He has made in the writ petition, my lord will find
Ah,
the Dibrugarh University, the Guwahati University to be the party.
okay. But how do we know that this college belongs to the Dibrugarh University?
That is there in the,
That ordered by the state government.
Huh?
Not by the, yes, ordered by the state government.
What order?
His order present, his order, appointment.
No, I'm not on that. This post that is to be filled up
Yes.
is under which university?
Yes.
The post that is to be filled up, this assistant professor post,
In that particular college,
which college?
in that particular college.
In that particular college is under which university?
Silapathar, in para 4 of my petition, I have stated. Candidate for filling up the post of assistant professor in Bodo language for Purvanchal College, Silapathar.
Yes, it's under which university?
Under Dibrugarh University.
No, I'm asking the writ petition.
Information was it was under the Guwahati University. So I made Guwahati University a party. But the appointment is by the state government, because it has nothing to do with it.
Let us see the appointment. Appointment of whom?
Appointment of assistant professor.
Who has been appointed as assistant professor? Who has been appointed? You have not been appointed.
Yes.
There was a
Not-
stay.
Yes.
So you are not appointed.
He was not appointed.
So where is the appointment? Whose appointment?
One more document is there, your lordship may kindly peruse that document. Annexure 2 at page 11
Of the writ petition.
of my stay vacating application. That was a letter by principal and secretary Purvanchal College, Silapathar. That letter was addressed to me. Sorry. I am to inform you that the meeting of the selection committee for selection of assistant professor department of Bodo of Purvanchal College, Silapathar will be held on 13th to at 9 p.m. Therefore, you are requested to present in the interview vote accordingly. That is by Silapathar, Dibrugarh.
Okay. So you see the issue is this. You have taken part in the
Yes, ma'am.
selection process as per the advertisement. End of the matter. There's nothing to be decided. Right. Right, mister? In the writ petition, in the writ petition.
J. Sharma.
Right, mister?
J. Sharma.
J. Sharma, learned counsel for the petition. Also heard
Item
Mr. D.P. Kalia, learned senior counsel. Assisted by Mr.
I am.
I am it. Appearing for the respondent number. For which respondent? Appear. Okay. And Mr. D.P. Talihal, learned counsel appearing for the petitioner, along with assisted by Mr. Silso, huh? And heard Mr.
J. Sharma.
J. Sharma, learned counsel appearing for the
For the petition,
private respondent number
respondent number 5.
5. Who is appearing? Mr. P.J. Handy, P.J. Fukan appears for what university? Mr. S. Das appears for Education Department. Yes. Mr. H.P. Niyog appears for number 4. How many writ petitions are here? Oh, wait. No, this Miss. Huh?
8. Ours is 8. Item 8.
No. Just a minute. You see, one thing. I'm in 6046. The issue is the same in all of them. Quite different. No. Okay, in all did you all participate in same advertisement? All participated. All of you all were all selected in 2016-17. Okay, you're a private respondent. You're a private respondent, and wait a minute. You are in Mr. Chaliha is in 6046. So Mr. Chaliha you're only in one, no? Only 6046.
No. In the all petitions, I am for the petition.
You are for the petition. And in all the okay. So I thought there's only one writ petition. So in all the 3 writ petitions, you had been appointed in 2016.
My lord, yes.
And you are challenging this advertisement.
On 13,
Huh?
I was there. In some cases, I have been appointed in 13 also.
In which one?
On
Contract.
contractual appointment. That's true.
In all the 3, you are on contract basis.
Yes.
All the 3 are on contractual basis.
Right.
And you took part in the advertisement.
Yes.
Same advertisement. Same advertisement.
Yes.
Same. He resigned. On what ground? What is his prayer? What is his prayer in the writ petition? So if he has resigned, then what remains?
Where is that?
So you have resigned and participated.
My lord.
You resigned your contractual appointment and then you participated. What then end of the matter? On what ground are you challenging? There's nothing to challenge. Okay, right. Huh? Common order. Common order or separate order? No, it's okay, it's okay. We'll dispose of the writ petitions and right. Common order. Heard Mr. D.P. Chaliha, learned counsel for the petitioners in all the 3 writ petitions. Assisted by Mr. Sir. Then who is for the government? Mr. S. Das appears for the Higher Education Department. Anybody else? For Mr. Fukan for? Appears for the Guwahati University. Who is respondent number 4? Principal of all the colleges. Same. Governing body of the same college. The college is the same in all of them.
No, different college. Different.
Oh, then how can it be? How can it be a common order? Huh? Okay, Mr. Spencer appears for the respondent number 4 in WPC number 6046 of 2024. 2023. Mr. What? MDK. M.
MBK.
Oh, MD Mohammed. MD Mohammed A. Raman. Appearing on behalf of respondent number. Respondent number 5 in WPC number 6047 of 2023. Okay. Mr. P. Bora appears for the respondent number 5 in 6044 of 2023. And
I
Mr.
in 604623.
And for respondent number 5 in
Respondent number 5.
WPC number 6046
46
of 2020. So all the advertisement, same advertisement. And- Okay.
Yes.
Okay. The petitioners, no, all the three writ petitions are being disposed of by this common judgment and order in view of the fact that the issue to be decided is similar. Next. The petitioner's case is that they were appointed as assistant professors on contract basis between the years 2013, 17, you 16, no? And who is for in the,
Item number 8, 2016.
and what about the other one, 7? In item 7? No, item 9, it was 17. And in item 7, item 8,
Item 8, 2016.
item 8, 2016.
Yes.
Then what about, there's another item, item 10, which feature? Let me see. Between the years 2000, just let me. 2015 to 2017. Huh? The petitioners, no, the thereafter, the which colleges? What are the names of the colleges?
Purvanchal College, Silapatha.
Thereafter, the Purvanchal College, Shirapathat, Tezpur College, and which is the other college? Huh? North Kamrup College. North Kamrup College, Bakbara. Issued advertisement calling for filling up the post of assistant professor in various disciplines. Correct?
Only in borrowing.
Okay, in all three of or in the assistant professor in the department of Boro language. Or in the department of Boro language. On regular basis. Full stop. Next paragraph. All the three petitioners who are serving in their respective colleges on contractual basis resign from their post. Correct? Resign from their post and
No, only one reason.
okay, only in item 9. In yours, they did not resign.
Item 8, not.
Okay,
No, others not.
okay, right. All the petitioners participated in the selection process pursuant to the advertisement dated 28, is it same or same advertisement date? Same advertisement. Oh, pursuant to the advertisement dated 28/12/2022 for filling up the post of assistant professor in the department of Boro language on regular basis. In fact, the petitioner in WPC 6044 of 2023 resigned from his post of professor on contractual basis to participate in the thing. Next paragraph. The petitioners were, however, unsuccessful in the selection process, and the private respondents in all the three writ petitions, correct? All the three writ petitions have been recommended, have secured the highest mark.
Yes.
For being appointed to the vacant post of assistant professors in the various colleges in person to the advertisement dated 28/12/2020. Next paragraph. The petitioners council submit. Yes, what is your case? The petitioner's case is that as the petitioners have been serving as assistant professors on contractual basis for a long period of time, their services should be regularized in the post of assistant professors that were advertised in the advertisement dated. The petitioner's prayer is for setting aside the selection process made pursuant to the advertisement dated principle and also the advertisement dated principle itself. The further prayer is that the respondent should be directed to regularize the service of the petition. Next paragraph. The counsels for the respondent, on the other hand, submit that as the petitioners have participated in the selection process for filling up the post of assistant professors on regular basis, they have waived their right to be regularized. In fact, for respondent number, in fact, the writ petitioner in WPC 6044/2023 has already resigned from his post of assistant professor on contractual basis, and as such, he has got no locus standard to make any claim for regularization. I have heard the learned counsel for the party. As can be seen from the submissions made by the counsel for the party, the petitioners were appointed as assistant professors of the three colleges in the Department of Oral Language on contractual basis. The petitioners, being desirous of being recruited to the post of assistant professors in the Department of the Borough Language on regular basis, pursuant to the advertisement dated 3rd, took part in the selection process. In fact, the petitioner in WPC 6044 of 2020 had resigned from his post of assistant professor on contractual basis and thereafter taken part in the selection. However, none of the petitioners were successful, and the private respondents in all the three petitions have secured the highest mark for promotion, not for promotion, for selection and appointment on regular basis. It is the view of this court that as the petitioner has taken part in the selection process for appointment to the post of assistant professor on regular basis pursuant to the advertisement schedule. They cannot be allowed to turn around and challenge the selection process. In this respect, it would be profitable to refer to the judgment of the Supreme Court in the case of uh, Ramesh Chandra Shah and others versus Anil Joshi and others, 2013, 11 SC 309. And in the case of Ashok Kumar and another versus State of Bihar and others, 2017, 4 SCC 357, where it has been held that a person who consciously takes part in the selection process of selection cannot thereafter, turn around and question the method of selection and its outcome. In view of the fact that the writ petitioner had taken part in the selection process and has and were unsuccessful in the same, they have no right to turn around and now question and now demand that they should be regularized. And that their service should be regularized. The contractual service should be regularized. Next part. No, one of the reasons being that the petitioners have waived their right, waived any right that they might have for regularization of their. Further, in the case of the Supreme Court has said that there cannot be regularization of persons who are employed on contractual basis. Bela Fideli said. That is Bela. In view of the reasons stated above, there's the writ petition, this court does not find any ground to exercise its discretion in the present case. The writ petitions are accordingly dismissed. The interim orders passed earlier stands vacant. Then in the IA, right, in view of the order passed the main writ petition, the IAs are also disposed of accordingly. Since the
Please, Lordship. Lordship, my senior Miss B is on legs at this moment. I'll take her up.
Yes,
They have square an affidavit, madam.
Huh?
Can I have husband of the petitioner square an affidavit declining the pension?
declining the pension.
And
Where?
that is at page 21. Next to the
21 of the writ petition.
mile. Area salary.
Huh?
Area salary, my kindly picture.
Yes.
The area salary from 1195 to 27,295 are not available.
So what is he asking for in the writ petition?
Setting up that and watching the communication. That is 447.
Area retirement benefit.
Huh.
He's not asking for area salary. He's asking for area retirement benefit.
And
What is
page 27.
wait.
Like that page.
Yes.
Third pair, the area salary of students are not entitled by the retired. Here also by the same also. This is me to better.
Wait, let the senior come. Yes. Next. Yes, elementary education. Okay, no one appears for the petitioner. The petitioner claimed provincialization of its service under the 2017 Miss S. Tutia, another counsel for the elementary education department, is granted 4 weeks time to file affidavit in opposition. This is the matter of the court.
Hey, please, Allah, an affidavit in decline of is being filed within this week. May I pray, government please be taken up next.
Look, out here, it's very simple. They say that you are not entitled to the selection grade scale of pay. For the reason that you don't have MTech or a ME degree. That's
But lordship, the certain.
no. What is the requirement? What does the rule say for being entitled to the selection grade scale of pay? What does the rule say? Let us see the rule.
Lordship, that I, that reply I shall pay.
No, it is a law. We can see it together. Why do you want to waste time? Why do you want to waste time? We can see the rules together and we'll see what selection grade pay. What is required? What is the educational qualification required? Is it there? Yes, where is the rule?
In our affidavit, page 131.
Page 131. Okay. Yes.
Lecturer selection page. The senior lecturer,
131. Where? Okay. Clause 8.2.
8.3, madam.
8.3. That is at page 132. Anyway, mine is 132. 8.3, yes. A senior lecturer, senior, who has a master degree and 5 years experience as senior lecturer of lecture and will be eligible to senior selection grade, subject to the recommendation of the selection board. So, do you have a master's degree?
Not with PE, Lord.
Huh?
PE,
Look at this, page 132.
not with, that is subsequent development of, I had already next, my, finish on.
Ah.
Page 28,
Speak it.
page 28,
Yes.
November, that is 17/1/18, Lord.
Yeah.
Lordship, this is 29, Lordship. A 2.6, Lord.
Yes.
Lecturer who do not have PhD or a master degree in the relevant branch, discipline of a program shall be eligible for the AGP.
What is AGP?
Annual grade pay, Lord,
Okay, AGP.
of 7,000 only after completion of 9 years as lecturer. Then lordships pay, that is same page lordship, A 2.9.
Yes.
Lecturer with complete service of 5 years with AGP of ₹7,000 shall be eligible subject to other requirement. Clause 2.13 laid down by the AICT to move up to the AGP of ₹8,000. Lordship, on page 30, Lordship,
Yes, yes.
page 30, A 2.2, lecturer selection grade, completing 3 years of teaching with the AGP of rupees 8,000 shall be eligible subject to other conditions as prescribed by AICPM to move the pay band of rupees 37,400 to 7,000 with AGP of rupees 9,000.
No, no, you see, just tell me one thing. This lecturer selection grade, what is the pay scale and what is the grade pay?
Selection grade lordship. Selection senior scale I got it lordship.
I know, I'm not on that. The question is, what is the pay scale of a selection grade lecturer? Unless you know that, then how do we decide? What is the grade pay of a selection grade lecturer?
Witness day lord. Witness day.
Right. A genuine prayer has been made on behalf of the petitioner. The petitioner, his claim is that he should be granted the pay scale of the lecturer selection grade. Para 5 of the affidavit in opposition filed by the respondent number 4 is to the effect that the petitioner does not have the mandatory qualification of MTech/ME degree for upgradation of his pay scale to lecturer selection grade in the academic grade pay of rupees 8,000. Good stuff. Next. इस तरह हाँ clause 2.a clause A 2.9 of the OM dated 17/1/2018 and no, clause 2.A 2.9 and A 2.13 no, not 2.16 of the OM dated 17/1/2018 states as follows, huh? Page 29 and page list the matter. Well, after the week. What? List the matter.
I can be adjourned for today. Mr. R.S. Sharma is out of station. He is in Kohima. Wednesday or Thursday, Lord.
RS,
Misra. Okay. I am for the respondent number 7.
have you filed affidavit?
No, Lord.
Are you filing affidavit? Are you not filing?
No.
You're not filing?
No.
No, if you're not filing, then why you not have the what is the requirement? Huh?
I am not aware whether affidavit will file or not.
Yes, Mr. Bora, are you filing affidavit?
I have not filed.
That much I know. That's why I'm asking. Are you filing?
Here by the name of the spoken to further speak.
So there's nothing to file.
I have the inspector, I'll file.
Yes, Mr.
M along.
M. Alam appearing for the respondent number 7 and Mr. P.K. Bora appearing for the elementary education department are granted 3 weeks time to file affidavit number. This is the matter.
Here is the order dated 7/3, my lord.
May I please, your lordship, here your lordship instruction has received your lordship. I would like to place it.
Let him see, let him see, let him see. If you have made extra for your friend, 50 paisa only.
It was good for the petitioner itself, your lordship. They have recommended the time periods also. So-
For packet family
Yes, your
pension.
lordship.
Madam.
And
So
your
that's all.
lordship,
You're only entitled to for packet family pension, nothing else.
and your lordship, some documents has not been given by the petitioner itself. And due to the, your lordship absence, ongoing absence, your lordship, I have clearly stated here.
Period have to be regularized.
Huh?
That period have to be regularized.
Okay, that,
Your lordship kindly,
which period?
My lord, the husband, my lord, prior to my lord death, my lord, he is unauthorized absent, my
Unauthorized leave, of how much,
due to mental disability, my lord. Mental retardedness, my lord.
that was not been stated here, your lordship, but some,
no, you see, you have got to take a decision.
No DP has. been
Unauthorized absence period, you have, government will have to take a decision either to take a departmental proceeding, to initiate departmental proceeding or to regularize that period. You cannot keep it in limbo.
yes, your lordship, kindly, I would like to peruse the second last paragraph, your lordship.
Yes.
I'd like to read it. On the other hand, it may also well to be mentioned here that at the initial steps of claiming the pensionary benefit by the petitioner concerned, no documents such as service book, leave ledger, and the others in respect of the incumbent concerned could not be traced out. But after extending collective efforts from all concerned, that is from the headmaster of the school, this inspector of school, and the director of secondary education, Assam, some progresses like construction of duplicate service book and preparation of other relevant documents have been earmarked. So all the works relating to granting the pensionary benefit to the petitioner concerned have been made step by step, and hope the remaining work would also be completed within a very short time. Hence, may I able to request your honor to please your lordship. That has been mentioned. They have to construct everything, your lordship, from leave ledger and service book. So your lordship kindly, and your lordship initial stage before that first paragraph itself, it has mentioned for first paragraph, last 3 lines, your lordship.
First paragraph,
However,
first paragraph
onwards,
is only 2 lines.
however, onwards, your lordship, first paragraph, third,
That is the
last 3
second
lines.
paragraph, last 3 lines.
Yes, your lord. However, onwards.
Yes.
However, the matter is reviewing meticulously at this inspectorate, and the progress of the work is going on. I assume that a final shape for the whole process regarding granting pensionary benefit to the petitioner concerned would be made within 10 to 15 days from the date of issuing of this letter. So this letter has been issued on 21/3/2025, your lordship. From there onwards, your lordship, some time may be given, your lordship, to meticulously, your lordship, as they are reviewing everything, every documents, your lordship.
This petition has been filed in 22.
22. Some days has been mentioned, your lordship, 15 days, 10 to 15 days, they have mentioned it. And on records, it will stay, your lordship.
So, what to do?
Need your
Take the matter, my lord, after 15 days or 20.
20
my lord,
days.
Okay, right.
instruction, my lord.
Miss P. Das, Clerk Counsel for the Secondary Education Department has submitted a letter dated 21/3/25 issued by the Inspector of Schools, which states that the petitioner would be granted pensionary benefits within a short period of time. This is for compassion family pension.
Compassionate family, 19 months, died on.
The matter pertains to the claim for compassionate family pension as the petitioner's husband died in harness on
On my lot, 28, 2019. 20.
20/08/2009. List the matter. When? After the
After
meeting,
20 days,
after few,
after 20 days,
give a date.
deeply obliged.
Apply.
23.
It will not be completed by 26.
Regularize the PD of my lot.
Huh?
Ask my lot, regularize the PD of my lot.
I don't know, Miss Pitas, by 25th, nothing will happen. He is going to ask for time on 25th.
Your lordship, as per instruction, I am placing it, your lord.
And as per experience, I'm telling you.
So I
Anyway,
am able to obtain instruction, some positive instruction. Lordship,
Lordship, before my senior colleagues start, Lordship, on the same subject matter, similar issues are part of before court number 17, and those are scheduled to come on 27.
Lordship, actually those matter is similarly, but I have,
Item,
only on, I have,
21 and 22, Lord.
but that matter was filed on 2018 mile, and this matter was filed only on 2023 mile. The petition-
Subsequent new matters are also taken up with 6020.
with court number 23.
No, 17. Lord.
Who is that?
Justice A.D. Chowdhury,
that- but-
When is it being listed?
coming Thursday, Lord.
Then you will list it next week.
but the earlier-
Or you want me to do?
but packet matter was dealt with that matter.
I will not tag it with them. I will not tag it. I'll keep it separately. Let that decision come. And then you can,
It is very simple, fine.
Huh?
It is very simple.
I know
Each other, prayer-
that you want your,
Yes, sir.
you want your salary for the period from 2015 to 22. That's all.
After reading said they were regularly walking one, and that's because
So the issue is whether you were working or not.
yes, I am walking.
So your case is that for work done you should be paid. That is the,
On top, and they have filed their affidavit. and
no, but since similar, I don't want there to be a multiplicity of orders.
That meant a huge number of candidates, and some of their getting salary. and
No,
some of
madam,
their
you see,
salary is
you
not
see,
getting
you
from
see,
the
you see.
payment.
Madam, you see, one thing is that since that court is seized of the matter and is going to take a uniform decision, let us wait for that. And after that, I will segregate it. We'll keep it like this only. Let the decision come. If it's in your favor, you will say that yes, it applies to me. If it's not in your favor, then you will say that it does not apply to me. We'll see. That's what you're going to say anyway. On the prayer of the parties, list the matter after the week.
Let it come on 10K. Other matter is on 10K.
No, it will not finish in one day. It's got to pass. If it's a batch,
About
orders
50
will not.
cases are
If it's batch, it will not come. Okay, list the matter after 2 weeks.
It may be 6 months.
Huh?
It may be 6 months.
Date.
Yes.
Give it. Give it.
April. No. Yes. April.
Yes.
Yes.
specific after conflict method, can we allow some time to take it after the instruction?
Are you filing any affidavit?
Only the area salary is
Only the
pending.
areas
There is. Okay, all right, Miss today is granted
after a week.
granted a week's time to obtain instructions with regards to the payment of area salary to the petition. Miss,
I have some
based on behalf of the RS Betty. Estimated, counting for record number 5.
Madam, on date, a date will be given, madam. I think 6th of here, madam. Right.
What is this?
Already 31st March within that time.
How do you give?
I think 24.
Do you want 5th April? Do you want 5th April? It's a Saturday.
7th, madam.
But it's a working day.
That is
7th.
7th.
Okay, 7th. Item 24.
Yes.
24. Yes.
GA Assam,
Huh?
GA Assam seeks time to obtain instruction in this regard.
Great for
Yet for employee. Due to wrong calculation, madam,
not calculated in the year.
from 16, but 2016.
So the recovery order has been passed, well. Recovery order has been made over.
Well, recovery order has been made. Madam.
It has already been recovered over.
Not recovered.
Where is the impute recovery order?
On the page 14, madam.
Page
14.
14. 14. Where is the recovery order?
That only basis of this order, madam, he was pressurized. On the page 15, madam.
Page 15. They have got to, for waiving, they have asked to do this. So, how much is the amount?
60,000.
Huh?
60,000.
Where is that?
Page 14, madam.
Acha,
60,500, 5,600.
Where?
Reasons for recovery of 60,000
Page-
from the
page-
amount of provisional
Page 14, madam.
DCRG.
14. Order dated 10/3 to 2020.
Madam, yeah.
In persons to government letters hereby sanction for provisional pension of so provisional DCRG of okay, after deduction.
After it.
Some time may be given.
For
Your
what,
Lordship,
madam?
to
Waste of time.
Instruction.
Huh? Where is the?
As regards the reasons for recovery of that 60,000 from the amount of provisional DCRG.
Madam, come to the next page. Come to page 15. Please read.
With reference to the above, I am directed to inform you that while checking the pension proposal in respect of above named pensioner have the following deficiency for which this director could not finalize the pensionary benefit. The deficiency shortcoming in the service book pension paper may be examined, and if found in order, appropriate steps may be taken.
Please carry on.
Pay on 1/4/2016 may be fixed at the stage of 29,720, DP 25,820 plus GP 3,900 instead of rupees 30,620, and subsequent regularization of pay may be made up to the date of retirement. Excess drawal may be assessed with due to drawn statement. However, HDO may move to the competent authority to waive recovery in terms of para 8 government OM finance so and so date.
So, What has been done? This is 2021 order. This page 15 is of page 2021.
2021.
Now it's 2025, madam. You are not doing anything. He needs pay because he needs to eat, feed his grandchildren and give some sweets also to them. You know,
Last chance may be given
For
to
what?
lordship to obtain instruction.
Nothing will happen. I'll be only giving you time to ask for the same submission on the next week. That's okay, right. Right, Mr. Carefully. Learned counsel for the petitioner. And please ask learned counsel for the secondary education department. The petitioner has prayed for setting aside the impugned order number 10238 44 dated 10/3/2020, by which rupees 60,000 is thought to be deducted from the provisional DCRG amount of rupees 6,05,643 payable to the petition. Next paragraph. The petitioner's counsel submits that the petitioner retired as a grade 4 Chowkidar
My lord.
from the erstwhile from the Kekpuri Tribal High School.
Initially, my lord, he
No,
was
just a minute.
appointed as
From the amalgamated Kekpuri
fine.
Tribal High School on 30/01/2020.
31/1.
31/1/2020. However, the petitioner has not been paid his retirement dues.
And
Pension
retirement has been released. Regular pension has been not.
has not been paid his regular pension till date. In view of the excess salary paid to the petitioner due to wrong fixation of his pay by the state government, the petitioner's counsel submits that due to wrong fixation of the petitioner's pay by the state government, the excess pay of rupees 60,000 is thought to be recovered from the petitioner as reflected in the order dated, impugned order dated 10/3/2020. He submits that the wrong fixation of the petitioner's pay at rupees 30,620 instead of 29,720
From 2016.
from
1/4/2016.
1/4/2016 is the fault of the state respondent, and the same was not due to any fraud or misrepresentation on the part of the petitioner. He submits that in view of the judgments of the Supreme Court in the case of State of Punjab versus Rafiq Masih, bracket whitewasher, 2015 4 SCC 334. And in the case of High Court of Punjab and Haryana and others versus Jagdev Singh, reported in 2016 14 SCC 267, the respondents cannot be allowed to recover the excess amount paid to the petitioner. That's all. Ms. Pida, learned counsel for the secondary education department, submit first.
60,000 has been recovered, your lordship.
Has
From
been
that-
recovered?
so,
Not recovered. Going to be recovered.
Your lordship, we deducting of rupees 60,000 has been made, your lordship.
Made. Then we'll ask you to pay back.
To obtain, your lordship, pertaining to that, your lordship, to obtain instruction as regards the reasons for recovery of that 60,000 from the amount of provisional DCRG.
Well, I am submitting, not recover, but there is a stay order.
Cannot be a stay order.
There is a stay order, not to recover. This is making it confusing.
No, I'm on the law matter, man.
This is the law.
Forget the facts. Facts may be anything. Can we, what, you are saying that it should be recovered.
Yes, your lord.
Okay, submit that. As the,
We have to obtain instruction, because your lordship, instruction as regards reasons for recovery of that 60,000 from the amount of provisional DCRT, your lordship.
come again, I am lost. I got lost somewhere.
We have forwarded our letter also to the department pertaining to that. Your lord. Instruction is not received.
Submit that. Rupees 60,000 has already been recovered from the petitioner's DCRG amount. And as there is no prayer for returning the said recovered amount by the petitioner, the writ petition is infructuous. Is it?
Hmm.
Is it? So writ petition is infructuous. No, just in practice, there is nothing to decide in the present dispute. Huh? Okay, that's your case. Okay. I have heard the causes for the past. In the case of Rafik Masih Supra and Jagdish Singh Supra, the Supreme Court has held that it would be impermissible in law to recover excess salary paid to from a grade 3 or grade 4 employee, especially when there has been no fraud or misrepresentation on the part of the petitioner. In the present case, there is nothing to show that there was any fraud or misrepresentation on the part of the petitioner in receiving excess salary. In fact, a perusal of the impugned, no, in fact, a perusal of the order dated 10/3/2020, impugned order dated 10/3/2020, and the letter dated 31/3/2021 issued by the Finance and Accounts Officer, Directorate of Pension, SM, shows that the state respondents had wrongly made a wrong, had made a, don't say wrongly, they had made a wrong fixation of the petitioner's pay with effect from 1/4/2016 by fixing his pay at rupees 30,620 instead of 29,720.
Seven.
Next part. The impugned order dated 10/3/2020 and the letter dated 31/3/2021 issued by the Finance and Accounts Office is reproduced therein below as follows, huh? Page 14 and page
31, 15.
15. Okay. Next slide. As can be seen from the above, there has been, as can be seen from above, there is actually a request made. No, there has been actually um, the result of the above letter shows that the Directorate of Pension has allowed the Secondary Education Department to move the competent authority to waive the excess amount paid to the petitioner and which is thought to be recovered from the petitioner. However, till date, however, till date, nothing has been done by the respondent. Even though this writ petition had been filed on 24/8/2020. Huh? One thing also right for her that Ms. P. Das also submits that despite instructions being sought for from the state respondents by letter dated 5/9/2020, no instructions have been received by them till date. Next. In view of the fact that, in view of the judgments of the Supreme Court and the fact that the excess pay made to the petitioner has been made due to the wrong fixation of pay by the state respondent, the state respondent cannot be allowed to recover the excess pay given to the petitioner, amounting to rupees 60,000, and which is reflected in the order dated 10/3/2020. So, accordingly, the respondents are directed not to recover the excess pay of rupees 60,000 provided to the petitioner, as reflected in the impugned order dated 10/3/2020. The impugned order dated 10/3/2020. No, that's all. The writ petition is accordingly disposed. Before that, you're right. However, the petitioner's pension would have to be calculated on the basis of the actual pay he is to receive at the time of the date of his retirement. The pension be paid, the pension be accordingly be paid to the petitioner as per his entitlement within a period of 2 months from the date of receipt of a certified copy. The writ petition is accordingly. Keep it. I think there's a 25. Right.
My friend is supposed to call the affidavit, but matter is regarding.
You want to be accommodated as teacher?
They were initially in the year 1995, they were appointed as stipendary teacher. Subsequently allowed to.
So you want to be accommodated as teacher now?
Yes.
That's fine. It's a PK Bora. No, different. The matter pertains to the petitioner's prayer to be accommodated as teachers instead of tutors. Mr. PK Bora, current counsel for the Elementary Education Department, can submit his affidavit within 3 weeks. 3 weeks. This is the matter of it.
My lord, after take me kindly, because 2 years it is pending.
If after you.
Yes.
Item
40.
40. We have adjourned the matter.
At 2 year long.
We have adjourned the matter, madam.
But the-
You cannot come as and when you like.
There
Yeah.
was technical problem, your lordship, with conducting the, rules, your lordship. And I was on the court number 80, your lordship.
What can I do? I cannot be.
At 2 year long. Right.
Okay. that's good.
Keep your-
Yes, my lord. There is a might happen to be that in the disciplinary appeal rule for there is a provision for appeal and the petitioner has not availed it.
Okay, there is a provision for appeal.
Then I have a judgment that it says that without availing that alternative remedy, the Honorable High Court should not exercise the jurisdiction of 226.
Yes, so there is an alternative remedy available.
My lord, in this case, my lord, what is happening is, my lord, there are consecutive disciplinary proceedings which has been initiated against me, my lord. I have been kept out of the post, my lord, from June 2023, my lord.
Look, Mr. Counsel, the issue here, you are challenging basically the review of your suspension order.
And the suspension, both, my lord.
Naturally, but then suspension, so how can you challenge? Then there is a provision under the, show me which manual?
My lord,
That one. Second.
page 440.
My lord, there is a
Page
provision.
440.
Rule 14, ma'am.
Oh, 114.
14. No. My lord, page
Four-
is 440. The
440.
rule is, my lord, 14.
Okay. Yes,
Yes, my lord. My lord, there is a provision in the rule, my lord, that it can be challenged, my lord.
where is the volume?
But in this case, my lord, what has happened is, because if your lordship see my list of dates, I've handed over one list of dates. I'll quickly take your lordship to the list of dates, my lord.
Look, the issue is simple. You are challenging the suspension order and you are challenging the review of the suspension order on the ground that it is cryptic. Those are the two issues.
My
Now
lord,
there is a provision for appeal. You go there. This appeal is here.
why I'm saying, my lord, filing an appeal before the authority will not bring any result, my lord, because what is
That
happened
I
in
cannot help it. That you cannot say whether it will help or not.
my lord,
When there is a alternative remedy available, and unless you come within those exceptions made by the Supreme Court, how can
yes,
we
my lord.
just
That's
do
what
away
I'm.
with it?
My lord, I'm trying to submit only that, my lord, because there is no bar of exercising power by your lordship under 226, my lord.
Huh?
There is no bar because there is a provision in the rules that does not prevent your lordship from exercising power under 226, my lord.
That is
What
there.
I'm
That
saying-
is there. But that is
Yes.
discretionary. It's
Yes,
our
my lord.
discretion.
So why your lordship will exercise the discretion, my lord? That's I'm trying to point out, my lord. What has happened in this case, my lord? Repeated disciplinary proceedings has been initiated against me, my lord. My lord, first order by which I was asked to stay away from my office, my lord, that was a compulsory direction for compulsory leave, my lord. That has been set aside by a separate single judge judgment, my lord. That I have annexed. Now, during the pendency of that matter, my lord, they have
I
passed
can't even hear you properly. Your volume is so low.
I'm so sorry, my lord. I'm so sorry.
Yes.
Uh,
What is your which para?
My lord, para 6, my lord. Para 6 onwards, the internal page number 4.
Yes.
Para 6 and 8. And even in page 5, my lord, you see internal para number 30, where it says that the court, while exercising its jurisdiction under Article 226, is deeply bound to consider whether adjudication of this petition involves any complex and disputed question of facts and whether they can be satisfactorily resolved. The petition reveals all material facts. The petitioner has any alternative or effective remedy for the resolution of the dispute. There are some.
Ah, this is not the resolution.
And my lord, kindly see page 5, my lord, which says, my lord, that
Yeah, other that means they're better than this.
even though a provision under
Where?
Act,
Page 5.
page 5, my lord, internal para 6, my lord, from above,
Yeah.
my lord, from above, fifth or sixth line, my lord, even though.
Yeah.
Even though a provision under an act cannot expressly out the jurisdiction of the court under Article 226 and 227 of the Constitution, nevertheless, when there is an alternative remedy available, judicial prudence demands that the court refrains from exercising its jurisdiction under the said constitutional provision. And here, my lord, in case that the authority has a jurisdiction, my lord, they are exercising their jurisdiction and the question of tax is involved. If if it is a question of pure law and the authority doesn't have jurisdiction, then, my lord, we could have approached the Honorable High Court.
My lord, am I audible, my lord? Am I clear, my
Yes,
lord?
yes. Say
My lord,
what you're going to say.
yes, my lord. My lord, in this facts of the case, my lord, this is in effect is a second suspension order, my lord. Because in June, 1st of June 2023, after that incident, my lord, I have been already asked to stay away from the office by an order of the government. Now that order has been set aside, my lord. And consequently, my lord, they issued a transfer order also. Now this is the third order, my lord, in the series of that facts only, whereby I have been asked, I have been suspended now, my lord. So therefore, my lord, this is not a case, my lord, where a simple order of suspension has been passed, my lord. There is a background history to this, my lord. Now, my lord, lordship will kindly take up my list of dates. I have handed over that list of dates, my lord. It shows, my lord, if your lordship sees serial number 6 and 7 of my list of dates. Lordship has that, my lord? Because this is because I have been kept out of the office for the last almost 2 years, my lord, now. Because my initial order by which I was asked to stay away is of 1st of June, my lord. Now, and this is the second disciplinary proceedings, my lord. The first disciplinary proceedings, they have not concluded. They kept it pending. They are not passing any order. Now, in between, my lord, when I challenged that before the single judge, my lord, they initiated second disciplinary proceedings. That also has been kept pending, my lord.
And they will issue notice, that's all. That's it. All right, mister. Yes, what is your name?
Rituraj Biswas, my lord.
Huh?
Rituraj Biswas.
Mr. R. Because learn process for the petitioner submits that the petitioner was suspended on 31/10/24 and the review of his suspension order was made on 27/1/2025, by which his suspension was allowed to continue. Issue notice returnable in 4 weeks. Mr. S. Das accept notice on behalf of all the responsible. He submits that in terms of Rule 14 of the Assam Services bracket Discipline and Appeal bracket was rules 1964. An appeal lies against an order of suspension. To the next higher authority, vis-a-vis the authority that made the suspension order. He also submits that though the rules do not oust the earlier rules, does not oust the jurisdiction of a court under Article 226 and 227 of the Constitution, judicial prudence require this court from exercising jurisdiction under Article 226 when there was an efficacious alternative remedy available. This is a matter of COVID to enable the respondents to
My lord,
obey further instructions and file affidavit. Full stop. But one thing, right?
may I make,
Mr. S. Das can produce the minutes of the provisional periodical meeting held on the basis of which the suspension of the petitioner has been accepted.
I'm grateful, my lord. In the meantime, my lord, may I make one request, my lord? My lord, can they make an endeavor, my lord, to finish the disciplinary proceedings, my lord? Because this has been going on for a long time. If they make an endeavor to finish it, my lord,
Let
the
us see. Let us see.
entire controversy will be
The
over.
petitioner shall also, the Mr. S. Das shall also inform this court as to the stage of the departmental proceeding that has been initiated against it.
Very good. Grateful, my lord.
May I? Not in this matter, my lord.
Item?
Response number 6 has filed an affidavit, matter. I have to file a reply to the said affidavit, matter. Only 1 week time, matter. Perhaps in the past week of only
Is there some stay order? No.
no. They have filed a affidavit, my lord,
You'll file it within a week.
within a week.
Mr. K. Udinlar, counsel for the petitioner, has granted a week's time to file affidavit in reply. To the affidavit filed by the
Response number 6.
reply number 6. List the matter after a week. Huh? Why? Is there any prejudice being caused to you? Then
I have also received one instruction.
you want to file affidavit or what? Okay. Mr. U. Sharma, learned counsel for the
Secondary Education Department.
Secondary Education Department, submits that he has received instructions and will file an affidavit within 2 weeks. Within 2 weeks. This is the matter after 2 weeks. Oh, sorry.
In this case, my lord, the look at the application for some of the very modern. And it's printed from the file my section in this case.
We have filed IA matter here for modification and cancellation of the order dated 8/11/2024 and 14/11/2024, whereby a status quo was given by. And look, here what happened, my lord, on 9/10/2024.
Look, so this SMDC is not available. So they are unable to give the midday meal.
Kindly have a look, order of 6/12/2024, my lord. On that order, my lord, the opposite party has been trying for filing a detailed affidavit, but without filing the detailed affidavit, it's a case of final disposal, my lord. The issue is very simple. SMDC has been dissolved without any inquiry, without hearing us. On the last occasions, my lord,
Then we'll decide this matter now.
Yes, my
Why you asking for
then
time?
my lord may decide it, my lord. Kindly have a look,
Tell
my
me.
lord, page number 33, my lord.
Just a minute. Page 33.
Mine.
Yes.
In pursuance of approval of District Commissioner, Lakhimpur, the SMDC of Intenia High School and Daulatpur Higher Secondary School are hereby dissolved. The principal headmaster of the concerned school are hereby directed to process for reformation of SMDC of both the schools immediately following the government notifications and guidelines. Here I am for Daulatpur Higher Secondary School. I am the president of that school, my lord. So our plea is that before issuing this order, my lord, no hearing has been conducted, no inquiry has been conducted, even notice was not sent to us.
What is how do you dissolve SMDC?
In this regard, my lord, in the earlier dates, my lord, direction was issued to the secondary department to produce the notification, and that notification has been produced, my lord. And that the relevant portion of that notification has been reflected in the earlier order of 6/12/2020. It's in the court, my lord.
Yes.
Here, my lord, it is in from second page of the order, my lord.
Yes.
3, my lord. serial number 3. It can be dissolved for mismanagement or other thing or against in complaint, my lord. In receipt of complaint against the FMDC from community organization, government officials regarding non-compliance of government order, instruction, negligence of duties and responsibilities, non-cooperative to implement government funded scheme for the improvement of school, the Director of Secondary Education Assam will institute an inquiry into the matter and subject to the authenticity of the complaint shall pass a rejoined order for dissolution of the SMDC concerned after giving due opportunity to the SMDC concerned. 4. The SMDC concerned shall stand dissolved with effect on the day of the order of dissolution. So, my lord, an opportunity of hearing to be given to the SMDC and an inquiry to be made if there is anything against the SMDC matter. But the impugn order does not include anything matter.
So, what is the term of a SMDC?
5 years. 5 years. 5 years.
Where do you get that 5 years?
No, if I have any matter that in the constitution, there is no specific mention of the term matter. 5 years.
When were you formed?
It formed in my lord. On 22, my lord. 19/4/2022, my lord.
19/4/22.
Right.
You were formed.
Right.
Yes. Any notice given to them prior to the impugn order?
No one. That order was issued and he has challenged this order.
That much I know.
Here, my lord, it is stated in pursuance of approval of the District Commissioner Lakhimpur, the Assembly
Mr. Council, the
Yes.
question is something else.
Yes.
The question is, was any notice issued to them? You've got no idea, completely blank.
regarding that.
Okay, you get this information. We'll give him one chance. Okay, right.
Already ordered to file, my lord, it will be better to dispose of this matter, my lord.
But they're not filing.
That is the problem, my lord.
When are you filing affidavit?
My lord, regarding the financial aid or financial benefits, it will be hampered because it is 31st March is coming, the financial year.
If it is hampered, you file an affidavit tomorrow.
Hello.
We will ensure that it is not hampered tomorrow itself. You file an affidavit,
No, that's not.
then probably they're not in a hurry. Your clients are not in a hurry. Why should we be bothered?
So, my lord, as per the partial modification of this notification, the Deputy Commissioner is empowered.
Empowered to do what?
To constitute the constitute the SMDC.
No one is saying that he is not empowered. You see, the issue is not whether he is empowered or not. The issue is whether the dissolution of the SMDC was done after issuing them a notice. That is the issue. Right. I heard the counsel for the party. The petitioner, who is the president of the school managing committee of Daulatpur Higher Secondary School, is agreed by the order dated 9/10/2024, by which the SMDC of the school has been dissolved. And the principal of the school has been directed to start the process for formation of a new SMDC. Next para. The petitioner's counsel submit that the impugned order dated 9/10/2024 has been issued without any notice being issued to the petition. And in violation of clause 3 of the what? Of the notification dated 6/8/2014. It is reflected in the order dated 6/12/2024, passed by the
2014.
6/8/2014, I know, but it was reflected in the order of 6/12/24.
Oh, hello, madam.
Full stop. Next. Mr. U. Sharma, Learned Counsel for the Secondary Education Department, shall obtain instructions as to whether any notice was issued to the petitioner in terms of clause 3 of the notification dated 6/8/2024 prior to issuing the impugned order. Clause 3 of the notification dated 6/8/2024 states as follows. It is out here in the order, last order. It is here, small. Big. That's all I think. Leaves the matter when?
Monday,
Monday, why so long? You can do it quickly, huh? Monday is a holiday, huh? When do you want?
Thursday, man.
Thursday? Day after tomorrow?
Yes.
Oh no, today is Thursday. Huh? Interim order to continue till the next day. You bring that small information, we'll decide the entire thing.
Time being item 12.
Item 12. Non-payment of area family pension.
Lordship, although Karbi Anglong Autonomous District Council, response number 6 was filed with their affidavit. I think the affidavit will be needed from the state of Assam, their lordship. This because prior to that, prior to 2003, the state of Assam delegated the power to Karbi Anglong Autonomous District Council after 2003, your lordship. Prior to that, it was ruled by government of Assam. So affidavit will be needed, your lordship.
Yes, madam.
This is one of petitioner services province in the year 2009.
2009.
Page 27.
Then where's the question? You are not a government servant prior to 2009. If your service provisionalized
Not
2009.
me, my husband.
Huh?
no?
Huh?
They have lost.
Whatever.
What happened in this case? The pension was not awarded to any of the retired employees. Then thereafter, we prepared a petition before this honorable court. They have issued a notification, my lord. They have taken one plea in their affidavit, your lordship. Paragraph 3, your lordship, may kindly have a look. Pursuant to the resolution adopted in the Assam Legislative Assembly on 12 April 1995, the Governor of Assam in exercise of his powers conferred under para 2 or paragraph 6 of the Sixth Schedule of the Constitution of India, and with the consent of the Karbi Anglong District Autonomous Council, was pleased to entrust and delegate the functions of 30
Which para are you reading?
para 3 of the affidavit filed by Response number 6.
Yes.
That in pursuant to the resolution adopted in the Assam Legislative Assembly in April 1995, the Government of Assam is exercise of power conferred under subpara 2 of paragraph 6 of the Sixth Schedule of the Constitution of India, and with the consent of Karbi Anglong District Autonomous Council, was pleased to entrust and delegate the functions of 30 subjects of departments, including the elementary education up to the level of higher education, to which the executive power of the state of Assam extends, to the Karbi Anglong Autonomous District Council, with effect from its publication of official gazette by Dr. Info. The executive powers of the state of Assam and administration in respect to the transfers of the department is vested to the council. That's true, your lordship, it's vested to the council. But what happened, your lordship? They have taken the plea when the notification was issued pursuant to a writ petition filed by one of the writ petitioner. That was filed by from our chamber in October. And And pursuant to that, your lordship, a notification was issued giving benefit to certain numbers of employees, and their plea was
No, madam, it's very simple.
My
This
lord.
case. When is the date you are provincialized?
lordship.
If-
My pleaded case is that the school was provincialized in the year 1975, and I have completed the mandatory requirement, which is under Rule 31 of the Assam Services Pension Rules for in order to get the pension, my lord.
Madam, it's a
My
very simple thing. When were your services provincialized? When did you join?
Lordship,
When did you join the school?
I joined because it was not under retirement.
Yeah,
died
when
while
did you
in
join the
service, my
school?
lord.
You see, you have said that the school was provincialized in 1975.
My lord.
1975. When did you join?
That is not on record. Even they have not preferred.
Now,
Yes.
in 1975, you were not in service. In 1975, you were not in the school as a teacher, or were you in the school as a teacher?
I died on, my husband died
My husband died when?
27 to 95.
27 to 90,
95.
27 to 1995.
Yes.
And your husband became a teacher of the school in which year?
Lordship, my case is that instruction, because we are laymen. I am a old lady. Your
No,
lordship.
madam,
My
yeah,
husband died.
madam,
Lordship, no.
whether you are
Not only
the
that
whether you're the oldest lady in the whole world also doesn't matter. The matter is we have got to decide cases on the basis of facts.
Yes.
So the fact that is required for you to get family pension or any pension as such from the government is that your husband should be a government servant
Yes.
from a certain date. Which is that date?
Fact as to what why they have disentangled me along with similarly situated person from getting pension. Lordship, can you have a look at NHA space 27?
Okay. If you can't give me facts, I cannot go on
No,
speculation.
Lordship, their plea is that page 27, Lordship, can we have a look?
Yeah.
Third paragraph, the area salary from 1195 to 31/7/2003 are not entitled by the retired families of expat teachers, as they have submitted an affidavit in this regard.
Well,
I pleaded case that neither me nor my husband has submitted an affidavit in order to give that title.
okay, that's gone. That's a different. This is an area salary. You're claiming area family pension. Correct.
My
Arvind?
lord.
Now, to be eligible for area family pension,
My lord,
your husband was to be in government service.
my lord.
Which year? From which year was he in government service? Where is his appointment?
Taken instruction.
Where is his appointment order?
Appointment and order is not before me, my lord, since it was provided by my old client, my lord. Since her husband predeceased her, my lord.
You cannot base your case.
Let them.
They
take
can.
the
They are not supposed to
instruction.
prove your case, madam. You are supposed to prove your case.
Because your lordship, it's a discrimination has been made to me. I'm relying on.
No,
yes, not
I don't
case,
find
my
any
lord.
discrimination unless you can produce some record
My lord,
showing that you are a government servant.
lordship, even if I have filed RTI application, they could not provide me the instruction.
And what to do? What to do?
Because my claim is that, lordship, I have not filed an affidavit, neither my husband has filed an affidavit in order to disentitle the claim of area benefit.
I'm not on that. Whether you file or not file, that
No,
is
I'm
not the
getting,
issue.
pension benefit, I'm getting it, my lord.
You're getting
Regarding the area part, I'm
that is
claiming.
for area.
My
I
lord.
want to know when you're getting family pension.
Yes, my lord. That since they have taken the plea, that affidavit has been submitted by the families concerned. So my plea is that I have not submitted any affidavit. They can place that affidavit at least, my
Your
lord.
husband died when?
Lordship, my husband died on 27 to 95.
27 to 95.
Lordship. I am claiming the area benefit 28 to 95 to 31/7.
Yes, madam.
Madam, my parents pays 21.
He says that she's getting family pension. Page 21.
In continuation of department notification dated 6/10/2009, the governor of Assam is pleased to accord the approval of the provincialization of service of late Hiren Chandra Das, ex-headmaster Kheroni, addressed the LP school under the Rongthon block, Karbi Anglong district, who expired on 27 to 1985 miles. His service was regularized on 6/10/2009 miles, and he next para madam.
Service was regularized on 6/10/2009.
6/10/2009. Next paragraph, it is mentioned that my late Hirat Chandra Das, expired LP school teacher, was within the 2,859 numbers of provincialized posts pertaining to 1411 numbers of provincialized.
Where are you reading? Which
My
paragraph?
next paragraph. That is next second paragraph. Late Hirat Chandra.
Okay, yes.
Hirat Chandra Das, expired LP school teacher, was within the 2859 numbers of provincialized posts pertaining to 1411 numbers of provincialized posts. The service of late Hirat Chandra Das, expired LP school teachers provincialized who have been working from date 1/1/1995 to 27/2/1995. Only this period while his petitioner husband was working with. On condition of the family pension is to be given with effect from 1/8/2003. From the date from which 2859.
So if he is working only for 2 months, where is the question of family pension
Roshni,
also?
can we see the next part?
My God, the petitioner, the area salary.
Lordship, that is third line, 1/1/95 to 27/2/95.
Correct.
Yes.
That is 1 month. Okay, 2 months. It's for 2 months only. You work for only 2 months. A person who has worked for 2 months. Okay, but after provincialization.
In future, provincial of Assam elementary education.
The arrears salary of are not entitled by the families of aspired teachers. Of late, as Srimati, the wife of late has submitted an affidavit in this regard.
Then produced before Honorable Marquis will.
What is this affidavit? You bring this affidavit. Okay, right. It has to shall produce the affidavit executed by the petitioner as reflected in para 3 of the notification dated 4/7/26 bracket annexure D of the writ petition. Huh?
The Arabic also has petitioner husband service was regular in the year 2009 mail.
Maybe, but then you see the period prior to regularization can also be counted for pension, etc.
But that is like.
List the matter after 2 weeks. Yes, item 13.
Lordship, in this case, the present position of the petitioner is not known. They have not factored evidence.
They have accommodated.
Huh?
They have accommodated as future.
File an affidavit.
That's tutor. In the cover it is. Show me. So he has he has forgone his claim for career pay.
Let them file their affidavit to that effect. They are making that submission without any basis. In other series of cases,
Have you spoken to your client?
I could not make the contact. I contacted.
You also contact him.
Yes.
Okay. Actually, it's you who should contact. Okay, right. Miss B. Boyan, senior counsel shall submit that she will communicate with the client with regard to whether the petitioner has agreed to forego his claim for arrears salary on being accommodated as a tutor by the state government. What is
Number
it?
3, my.
Huh?
Next is point number 3.
Number 3. Number 3. The names of Rumi Datta and 5 others are found in this understanding. The teacher category. They are accommodated as teacher or tutor?
Teacher, ma'am.
Teacher, not tutor, teacher.
Lordship, let them file an affidavit basing on record that they have forgotten that.
Why is it you want everyone to do something? Why don't you talk to your client and ask?
Lordship, my specific instruction, because there's not only this matter, the series of matters are there, wherein they have taken the same plea. When
No,
they
no,
have
I
filed-
agree. Look, even if they file an affidavit, at the end of the day, again, you have to ask your client whether you agree. Then
That's,
please ask your client. Well, you have got to ask your client. Let them say whatever.
now, if they find it, I have a chance to rebut.
Why not? If they file their affidavit, what will you do? You say, yes, I agree. Then
I will not agree.
you will go to your client and ask. So you do that now. End of the matter. This is the matter after 3.
But if there are 2 petitioners, their service have been provincialized as tutors. Now, our case covered by the division bench, that is regular case.
Who's appearing for the other side? You see, he says that he's covered by that Mohor Ali case. So you'll verify.
Right.
And actually, when you go into that, it's basically government is to consider. Miss S. Rutia for
Elementary
respondents number 11326. Is it? For the elementary education.
Right.
For the elementary.
1, 4, 5 and 6.
Education Department. And who's the others? For finance? RM, how do you spell your name? Barwa? BARA. And also for the finance department. Okay. Dispose of. Yeah. Yes.
Right, with your lordship. The petitioner applied for the post of deputy registrar in IIT Guwahati, and his grievance was that his name was not shortlisted for the interview to be held. The Honorable Court passed an order saying that interview him also along with other shortlisted candidates, and he has been interviewed, and the result is being kept in a seal cover because the court directed not to publish the results. Now, at this stage, I'm praying that since the interview has been held, petitioner has been interviewed, to be permitted to declare the result, publish the results.
Okay, but what about the issue regarding supposing he's selected, then what happens?
So then the result will be out properly selected. Then
Then
in that case,
you're not selected.
No, I am not on the result matter. I am on the issue matter.
No, but then you see, once the result is out,
Right.
then
Yeah,
and if you're not selected, if you're not,
It could remain the same.
you know,
Because
the
in the
result will
middle of
publish
a
not-
selection process, my lord, they
Huh?
are arbitrarily, my lord,
It is not additional crows, my lord. That's
No, no, you are allowed to participate. That becomes an academic thing.
not only because of me, my lord. There are thousand candidates are also
No,
there.
you see, you are not appearing for thousands candidates,
No,
thousands
but I am
candidates.
not
You are appearing for one petition.
but-
That's enough. So this is not a PIL.
If the result is declared, if he gets a number one position
Yes,
select,
if-
then is
Then we'll decide whether you should be given the thing or not. Text Prakash, that's your case.
Exactly. What I am submitting, my lord.
What
Even
you're
if, my lord,
submitting
say,
is
my
that
lord, even if I am selected, my lord, I am not claiming.
you're not claiming.
I'm not claiming that I should, since I am selected, so I am clearly of the issue, my. I'm not on that matter. I am on that matter that whether the additional criteria is matter, permissible or not. That is the only.
When they're permitting you,
he doesn't
that's
have
all,
any
another
more
matter.
than difference.
They're allowing you.
But I find the reason what I am not
Correct.
experienced matter.
You file the writ petition for what? Not to
Everything-
declare, to participate and to see the result. Now you're getting everything. What more do you want?
No, my lord. That
No, enough. I
this
know.
is the issue, my lord.
Maybe that is.
My lord, in the meantime, my lord, what my lord?
Heard Mr. F.
My lord, 11 March, my lord, they filed an affidavit, my lord.
No,
So, my lord,
no,
I
Mr.
filed my reply, my lord.
No. Heard Mr. F. Learned causes for the petitioner. When is that? IA? You filed IA?
No, my lord, it's in a-
No.
No.
In your affidavit. In your affidavit.
no, we have filed an intimate the honorable court that interview has been held. Petitioner also has been interviewed.
Okay.
Now our praise that we may be permitted to publish.
Have
the
you
result.
have you made it in your interview? Okay, in your
Yes, yes,
affidavit.
in the affidavit, we have stated that. What? Affidavit we have filed on 11th March. And
Okay, right. Heard Mr. F. Learned causes for the petition. Also heard Mr.
Artika,
R.P. Kakapki, learned counsel, senior counsel, senior counsel for the respondent, IIT.
Lordship.
Got
Therefore, we have stated
My
that.
lord, if the affidavit not there, it's not even controversial, my statement is there.
How does it matter? Everything has been allowed. You should be happy. You have got an ulterior, some other game plan. Unfortunately, they don't mind declaring you your results. Also. So operation successful, patient dead, or what?
Yes, it is definitely.
That cannot be true.
Yes.
Ourselves
I
do not
am
know
very much
the
happy.
result of the.
But what to do? You challenge the result then. What to do?
That liberty,
What liberty? I'm not giving you any
yes,
liberty.
liberty.
Your liberty is always there. I don't have to give you. I'm not going to say anything. Right. But supposing he gets selected, then he'll be appointed or what?
Then that issue will come.
Then it will come.
That
Okay.
will come.
No,
That-
so we'll keep the writ petition pending.
Lordship.
Have you got the result with you?
No, result is been published in the seal cover. Lordship. Because it has been kept, Lordship directed to keep it, not to declare it. It is there in the seal cover. They have provided us, Lordship.
I can open it. End of the matter. We close the entire issue now. How many posts? One post.
One post, single post.
So now either SCOC will have some tea with laddus or
On Mondal, which is
your name is Dr. Upako Sharma. Okay,
Sanjay,
end of the matter.
once Sanjay
We,
Mandal.
we'll close this. Be assured that you're not there. You're not selected.
Sanjay Mandal is there.
I'm not saying who. Let them say.
Since the logic is already opaque, well, nothing is there.
I'm just going to say that you're not the one selected.
I know. Because the logic also can.
Huh?
Definitely we are not going. It is
Ah. So why do you want to
very
delay?
clear.
Why do you want to delay the inevitable? So right. Huh? Ah. Right. Now, right, so, huh? The petitioner's case is that, then they carry on from here. Is that in terms of, the petitioner's grievance is with the fact that his name was not among the shortlisted candidates for interview. In view of the respondents having modified the eligibility criteria. But the shortlisted candidates, not for interview, for select, for whatever I said. Candidate, for the interview. For appointment to the post of deputy registrar. In terms of the advertisement dated 10/3/2020, come on. In view of the fact that the criteria for, in view of the fact that the eligibility criteria had been changed. The 5 years experience required for an assistant registrar to deputy registrar had been changed from 5 years to 11. Next paragraph, right? The case of the petitioner is that, then it then it takes para 1, para 2. Then you write next. This part, right, interim order dated 5/2/2025 has directed the respondents to also interview the petitioner pursuant to the advertisement dated 10/3/2024. Next. The respondent number the respondents have submitted an affidavit dated 11/3/2025 stating that the petitioner, along with other candidates who were interviewed pursuant to the advertisement dated 10/3/2023, 10/3/2024, you know, 24 or 23 advertisement.
23.
23. And as such, they wanted this court to allow them to publish the result of the interview. The result of the interview, which has been kept in a steel cover, has also been produced before this. I have opened the same and I have found that though the petitioner was amongst the list of candidates who had appeared for the interview, the petitioner has not been selected for the sole post of deputy registrar. pursuant to the advertisement dated 10/3/2020. Next fact. In view of the above fact, comma. In view of the fact that the petitioner has not been selected by the selection committee, this court is of the view that the issue raised by the petitioner would only be of academic interest as on date. In that view of the matter, this court is of the view that there is nothing to be decided in this writ petition any further. The writ petition is accordingly, consequently, the respondents are allowed to publish the results of the interview in person, held pursuant to the advertisement dated. The writ petition is accordingly closed as in.
Oblige.
What to do? Huh? You can challenge the selection. Which item? 30.
Here, this order at page 76 has become in.
Infractors, yes.
Because the petitioner has been appointed as principal scientist with effect from 1/7/22.
Okay, right. Mr. R. Dubey, learned counsel for the petitioner, submits that the writ petition has become infractious. Mr. I. Thakur appears for
Assam Agriculture University.
Assam Agriculture University, while Miss
T. Wapangla,
T. Wapangla
6.
appears for his point number 6.
Only your lordship may indicate that it's been posted when an answer post.
Okay, in view of the petitioner having been, Mr. Spencer submits that the writ petition has become infractious in view of the petitioner having been appointed as chief scientific officer.
Principal scientist,
Principal scientist, where?
Kaikuchi.
Huh?
Kaikuchi.
Got it?
Horticulture Research Center, Kaikuchi.
Horticulture is
With effect from 1/7/20.
from 1/7/22.
22. Yes. This is of 19 blood, transfer of.
The writ, in view of the submission made by the counsel for the petitioner, the writ petition is closed as it.
If
As per perusal of last order date, your lordship's private respondent number 7, your lordship, Lavazna order effective. Service report completed.
But what about the facts of this case?
Yes, but the respondent.
Yes, you want to be promoted to the post of what? Office assistant.
Post of get
Office assistant.
Yes, my lord. Actually, the respondent number 1, 2, respondent number 6 is the main party.
Huh?
Inspector, respondent number 6.
No, Mr. Counsel, just tell me one thing.
They have to file the affidavit.
What is the rules for promotion?
My lord, that if the petitioner completes 5 years of service,
Ah,
as per the notification,
let us see the notification.
my lord, yeah, sir.
Right?
Okay, the petitioner. Unit has specific okay. Notification.
Which one? 5-1, 5-2, which one?
He is qualified, my lord, and he has rendered nearly 10 years service in the grade 4 And he is doing all this, all the methods of.
Look, you have shown me the recruitment rule for junior assistant and library assistant.
5% of the total cost of junior assistant. 5-2 months. Okay, district shall be picked up by direct increment from the candidates.
From direct recruitment.
Yes, yes, my lord. From the
It's
candidates
not
of the
promotion.
Get for top of the school under the concerned district having requisite qualifications with 5 years experience of continuous service as get for and remaining posts shall be picked up by direct increment from the.
Again, direct recruitment. Where is the promotion?
Yeah, they should hold me, they should promote me because I have completed more than 10 years.
Mr. Council, the rules, where does it say that you can be
Let them
promoted?
Direct
Huh?
recruitment, it was clearly stated direct
Correct.
recruitment.
Yes, no, my lord, let them hold the interview.
I-
Lots of
Acha,
times-
you want to be directly recruited.
No, my lord, direct. yeah,
What do you want? You want to be promoted? You want to be directly
I should
recruited?
be promoted on interview. Let them hold the interview,
When there is no provision for promotion,
my lord.
where is the question of promotion?
Now, just a minute, my lord. The post of grade 4, then I got this 2, 5% should be that column 1, my lord, equipment post gather of junior assistant and library assistant as mentioned in rule P2A, for the official senior secondary school, higher secondary school, high school, shall be made by direct recruitment.
Correct.
Yes, on the basis of selection of the district selection committee. I am not on that. I am on 5-2.
Please read 5-2.
5%
Ah,
5% of the total cost of junior assistant of a district shall be filled up by direct recruitment from the candidates amongst grade 4. The public schools under the concerned district having requisite qualification with 5 years experience of continuous service as grade 4 and remaining posts shall be filled up by direct recruitment from the open competition.
correct.
So 5% is reserved for us.
Reserved not by way of promotion, by way of direct recruitment reserved for you.
Both are
So-
direct recruitment. One is
From one is reserved only for grade
No,
4 and one is for open market.
my lord, is for 5%, and I am in the 5% quota. And lordship condition, last order passed by the High Court, last order may be condition. Last order of the honorable.
The problem, no, actually, he wants to take part in the direct recruitment process.
Here, your lordship, on
But then the problem is your prayer is wrong.
prayer is.
In
here,
your prayer, you ask for promotion.
For promotion is there.
That's
Nowhere it was mentioned
No,
he
no,
should
no,
be
no,
allowed
yeah.
in the interview, to sit in the interview,
lordship,
where
not
it,
That is last order may be seen. Of the last order. of the
I have
court.
objection, your lordship,
No,
regarding
lordship,
that.
let me read the last order.
Last order.
Last order.
Yes,
of the
what
court.
does last order say?
On 7/12/22.
Ah.
An order was passed by the honorable.
I know, very long order was
Yes,
passed.
condition
Yes.
that order,
So-
my lord. 7/12/22.
Other copy.
No, this is order of this court,
7/12.
22 order.
And there will be my lord condition. If court has held that this rule, my lord, there was already a challenge to that rule. The present, this 2018 rule. And my lord, the court, the paragraph, the page, paragraph of the order, the para, yes, my lord,
Unfortunately, no case.
lordship condition, no, condition, lordship.
There's no point.
Last sentence may be seen. Issue notice returnable by 8 weeks. Mr. E. Burman, other government advocate, Assam, Mr. Action, which is the land spending council, secondary department, and Mr. A. Shidla, land spending council, finance department have actually notice on behalf of September 1, 2, 3, 4, 5, 6, and 4 actually. No permanence need to be issued to the respondent. Petitioner shall have requisite extra for copies of this petition, including the annexures appended here to Ms. M.S. Burman, and government advocate Assam, Mr. Shishpil, land spending council. The respondent number 2, 3, 4, 5 shall file their affidavit.
Maybe.
They have to file the affidavit.
No.
No,
I can decide without affidavit also.
Lordship wants it.
Here, your lordship.
Mr. Council, Mr. Council,
That's the minimum. That's the that's the minimum. Prayer of petition. As per Anishimala, in the fair portion. Okay. In the approach of previous that it is most humbly paid that your lordship will be graciously pleased to admit this petition, all for a record, and issue a rule calling upon respondent as to why, to spoke as to why, it shall not be issued to respondent for promoting the petition.
for promoting.
That's the
Direct.
as per service
Offense.
2018.
Correct.
2018 rule my lord is amended now.
Okay, show me the amendment.
So now what happened?
Show me the amendment.
My lord, that High Court in this last order has said that was challenged by some other petitioners, and that is why the High Court has said that on 7/12, on 7/12, put the order. 7/12 order.
You mean this one? This one that you have given me?
What is happened? This during this pendency of this case, they have brought somebody else and filled up the post of the student and have filed a petition, and the representative state that matter. That the representative along with that this case.
Read petition state the matter. Which read petition state which
Yes,
matter?
That case number, I'm mentioning this case number. Case number is, my lord, 630. 638 of 15, 215, 225. 638 of 215. What's the condition? No, 638.
25.
Because both the case has to be heard together.
Mr. Council, that you see, you don't have to go to some other matter and to
No, no, my
decide.
lord, that
You should stand on your own legs. Why do you want to hide behind somebody else's case and fire a gun from their shoulders?
my lord, another man is got on transfer on his own request to fill up this post. So there is nullified order of the government.
And then you challenge that. Have you challenged that?
Yes, absolutely.
Where? Where?
That is the order you look.
That is a different case. I am not bothered with this. I'm bothered with this case.
In
The
this case, I have
present case, your
in
lordship.
this case, I have filed an IA. IA is their lordship. In this case also. I have filed a long back and IA.
Mr. Council, this is not a question of IA, no IA. The question is this. You have asked for promotion.
Yes.
The rules do not provide for promotion. There-
Concern on interview.
Huh?
Concern on interview. As per.
So where is
That is a direct recruitment post. It is not a promotional post.
My lord, the relief can be molded by lordship. And she, as per this rule, I trade the.
Okay, I can say that whenever the process starts
My lord.
for filling up that 5%, if he comes within the consideration zone, let him be considered. That's all.
That will
But
do.
your lordship, with
that will
that
do.
thing, but that thing does not mention here, your lordship. Here only, means petitioner wanted respondents for promoting the petitioner to the post of office assistant as per Assam Secondary Education, Provincialized School Service Rule 2018, where it has clearly stated that sub-rule 2 and sub-rule 2 of Rule 5, where as per your lordship manual, page 26, sub-rule 5, sub-rule 2, 5, your lordship, it was clearly stated that 5% of the total post of the junior assistant of the district shall be filled up by direct recruitment. Nowhere it was stated of promotion.
Correct. So, no, promotion, to no chance. Promotion, to we cannot.
He's crystal clear here,
But
your
also-
lordship.
So,
Then
so we will.
he should find fresh
No,
one,
no,
your
we
lordship.
just clarify that since there is no provision for promotion, there can be no,
To file our affidavit.
no, madam, please understand. I'm not allowing you or you. The question is this. When he has asked for promotion, that cannot be granted. I'm not granting that. I am just going to say that since Rule 5(2) provides that 5% of the post of junior assistant can be filled up through grade 4 staff by way of direct recruitment, as and when the government starts the process for filling up that 5% quota, for grade 4 staff, the petitioner may be considered if he comes within the consideration zone. That's all.
Yes.
Your Lordship, here,
Order
Your
is
Lordship,
a very innocuous order. What do you want?
direct
Nothing
recruitment,
can be given beyond that.
direct recruitment is still here, Your Lordship, there, Your Lordship.
What?
Direct recruitment is there, Your Lordship.
Correct, that's what I'm saying. Ah, correct.
Grade four,
By the correct, by the
oh,
yes.
not process.
Correct, by the, as per law, as per the procedure. If he comes within the consideration zone, as per the procedure. Correct. No, no one is harmed. That's all. But there's no promotion can be given. Promotion, we have no right to promotion. Ah. Oh. There's no point keeping this case pending now. Huh?
I'm a graduate. And I computer, all computer.
No, that is not the
Your
issue.
Lordship is correct. Let me participate in the interview.
Whenever they start the process,
Yes.
no one has a right to a certain post as soon as it becomes vacant. It's only when the government decides to start the process, then you have got a right to be considered
Yes.
if you come within the consideration
Yes,
zone. That's all. Heard Mr. R.C. Cycle, learned counsel for the petitioner. Assisted by Miss,
For,
also heard Miss P. Das for,
I'm appearing for 2, 3, 5, and 6.
Miss R.M. Barwa for,
Respondent for.
Miss P. Saikia for what? Okay. Right. The petitioner, who is a grade 4 employee, where in Karupetia Higher Secondary School, has prayed for promotion to the post of office assistant, to the post of junior assistant, on the ground that he has been working
For last 10 years.
as a grade 4 employee for the last 10 years. So, sir, Mr. R.C. Saikia has relied upon Rule 5 bracket 2 of the Assam Secondary Education bracket provincialized schools bracket close service rules 2018. Hereinafter referred to as the 2018 rules for being promoted to the post of junior assistant, which is a grade 3 post. Full stop. Miss P. Das, learned counsel for the secondary education department. Miss Saikia, you're for whom? You're not required. P. Das is enough, no?
Since he has.
And Miss
given
and
a
Mr.
statement, Your Lordship.
And
so-
Mr. P. Das, P. Saikia, appearing for the respondent number 1, submit that the petitioner's writ petition would have to be dismissed in as much as there is no provision for promoting a grade 4 employee to a grade 3 post in terms of the 2018. That's all. Anything to say, madam? I have heard the learned counsel for the party. Rule 5.2 of the 2018 rules provides us for. I just say, no, just say Rule 5 of the 2018 rule does not provide for promoting a grade 4 employee to a grade 3 person. Rule 5 provides that the that recruitment to the cadre of junior assistant and library assistant is to be made by direct recruitment on the basis of the selection of the district selection committee constituted under Rule 6 bracket 2 in the manner prescribed under sub Rule 3 and guidelines issued from time to time by the Education Department. Rule 5.2 of the 2018 rule provides that 5% of the total posts of junior assistant of a district shall be filled up by direct recruitment from the candidates amongst the grade 4 staff of the schools under the concerned district, having requisite qualification with 5 years experience of continuous service as grade 4. And the remaining posts are to be filled up by direct recruitment from open competition in the manner prescribed under sub Rule 3 of Rule 5. Full stop. Next para. As can be seen from the provisions of the 2018 rule, Rule 5 of the 2018 rule, there is no promotional avenue of a grade 4 employee to the post of junior assistant. The only procedure for appointment as a junior assistant is by way of direct recruitment. Grade 4 employees of a school can also be appointed by way of direct recruitment to the post of junior assistant, provided that, limiting the post reserved for filling up by way of direct recruitment from grade 4 staff to 5% of the total post of junior assistants of a district. Full stop. Next part. In view of the above facts and Rule 5 of the 2018 Act, the prayer of the petitioner for promotion from a grade 4 post to the post of junior assistant cannot be granted. Full stop. However, in view of Rule 5.2 of the 2018 rule, the state respondents are directed to consider the case of the petitioner for promotion to the post of junior assistant, as and when the state respondent decide to fill up the quota reserved for direct recruitment of junior assistant from grade 4 post. Full stop. The same is, however, subject to the condition that the petitioner comes within the zone of consideration and is eligible to be considered for direct recruitment to the grade 3 post in terms of the 2018 Act and the guidelines that may be issued from time to time by the state government. That's all. The writ petitions accordingly disposed of. Okay, madam? Aye. Madam, 32, what is this? Milan Barwa, what is this? No, I don't need this. This Item 32. What is the, yeah, I think it is infructuous. You see, what is the, eh, I think the SMC is for 3 years, correct?
Here.
And this was constituted on 17/11/21. So in 24 November, it was became infructuous. Right.
So that you can.
No one appears for the petition, no one appears for the petitioner. Mr. P. Saikia appears for
Respondent number 4, Madam.
respondent number 4, while Mr.
D. Pegu, my lord.
appears for
1, 2, 5, 6.
1, 2, 5, and 6. The counsel for the respondent submit that the term of a school management committee is 3 years. Correct? 3 years. In terms of which provision? You know,
But that's rule 13(1). Roman 1, the Assam right to write that 3-year compulsory application rule 2011.
this one in this book, Assam Education Manual, or where will it be?
That manual, my lord, that is not
Yeah.
available in that manual.
Out here.
A small one.
Assam,
Assam
which,
right of silence to free and compulsory education rule 2011.
rule, which one? Which rule?
Rule 13(1).
In terms of rule. No, what is the rule or act?
Another rule by
What is the rule, name of the rule?
Assam right of silence to free and compulsory education rule 2011.
The Assam right.
It was reflected in the last
Acha,
That is-
okay.
30/8/2023, and that the mobility was expired on 9/12/2023. That's reflected in the order dated. 30/8/2023.
Okay. Hmm. Just a minute. It is not here also. Acha, the act is here.
Rule 2011. When my lord, petition also stated in the paragraph number 12.
Okay, sir.
For 3. Paragraph number 12. my lord, says
Sir.
the petitioner begs to submit it in terms of the rule 13(1). Roman 1, the Assam right of child to free and compulsory to 2011. Amended terms of assembly is for 3 years.
Oh, yes. What have I said? In terms of rule 13 bracket 1 bracket Roman 1 small. Huh? 2, that means 1, huh? Of the Assam right of children to free and compulsory education rules, 2011. They submit that the SMC was constituted on 17/11/2021, and as such, the SMC is no longer
Term expired on 9/12.
is no longer is invalid as on date. In view of the submissions made by the counsel for the respondent, the writ petition has become invalid, has become infructuous. That petition accordingly dismissed as infructuous. Today I filed the color for F1 number 4, mother. Right to file an affidavit. Each time it required. Mr. UK Goswami, learned counsel for the respondent number 4. And Miss P. Das, counsel for the Secondary Education Department, is granted 3 weeks time to file affidavit in opposition. This is the matter of receiving.
Keep it right.
Your lordship, my lord, since it takes a referral, but he has filed affidavit. I want to file reply on that.
That time we gave you time last time also.
Last time also, your lordship.
I could not contact the petitioner, my lord.
Miss S.B. Chowdhury, learned counsel for the petitioner, is granted a further 4 weeks time to file affidavit in defense. This is the matter of the 4 weeks.
35, my lord, I paid for 1 week time to produce the report, as per date, order dated
Okay, Mr. G. Pegu
6/5/2000.
is granted a week's time to produce the report. This is the matter after the week.
Apply, sir. But here, I have filed another WPC 1266 of 2025. This matter may take along with that matter. There is an order in 126.
Yeah, for the writ petitioner. Yeah, for the writ petitioner.
He is for it.
Yeah, for the writ
I'm
petitioner.
from the Kolkata.
Yeah, for the,
Kolkata.
huh?
Kolkata.
Who is for the writ petitioner?
It's not me.
Yes, what is
I
it?
have filed.
Yeah, fine.
And I am 40.
We can dispose of this matter.
My lord, I am the respondent number 6. Against the order, the impugned order in the IA which has been challenged, I have already filed writ petition,
Madari.
and in that writ petition, there is an order that this matter may be taken along with that.
Okay, so your appointment is being challenged.
My
Correct.
appointment is being challenged
On what ground?
on the ground that there was in interview, mark has been wrongly given me, and without I have submitted blank OMR sheet, but mark has been given. This is the ground. But now the director has issued a letter, my lord, in the IA, my lord, can you see page 10? Can you see page 10 of the IA?
Yeah.
IA. With reference to subject cited above, I am directed to inform you that after verification, so-and-so, appointment of so-and-so, Gitabala Roy, I am the Gitabala Roy. As library bearer, so-and-so, received from your end, right proposal under reference number. It is found that your advertisement against the state post followed 100-point roster system of the post-based basis, but you should have been advertised against the state post following 13-point roster system of rotation basis. This letter I have challenged my, because why I have challenged? Because earlier roster approved by the director, on the basis of that roster, advertisement was it.
So
Now,
we will have to see which is the correct roster. That's all.
yes, sir. So it is not in the present writ petition. The writ petition which I have filed, there I have challenged the roster.
Okay, right. You are the writ petitioner, Miss D.K. Mathur Mahato appears for the writ petition. Mr.
Respond D. Mohanta. Respond number 4.
D. Mahanta appears for respondent number 4.
I am for respondent number 6.
Mr.
Yes,
S.K. Ghosh appears for respondent number 6. The petitioner has put to challenge the appointment of the respondent number,
selection.
the selection of the respondent number 6 as
Library bearer,
library bearer.
library.
Library bearer.
Grateful.
On the ground that the advertisement was not correct in as much as instead of the 100
No, that was not.
was not correct. Why was it not correct?
Nothing.
No reason.
No reason.
Not correct. Full stop. The Deputy Director of Higher, the Deputy Director of Higher Education has, in the meantime, by letter dated 28/6/2024, informed the principal of the Kila Rai College that the advertisement on the basis of which the respondent number 6 has been correct was not correct, in as much as the post had been advertised by following 100-point roster system instead of 13-point roster system. Next paragraph. Mr. S.K. Ghosh, Learned S.K. Ghosh, Learned Counsel for the respondent number 6 submits that the submits that the letter dated
28/6/2024.
Huh?
28/6/2024.
issued by the Deputy Director of Census has been put to challenge in WPC number
1266/2025.
1266 of 2025. Leave this matter after 2 weeks along with WPC 1266 of 20.
The date may
You did. After you. Yes, it's your anatomy.
Yes, ma'am. My lord, by the last order, my lord had asked us to take dusty on the Ames authority. It is, my lord, the case regarding to.
Did you participate?
Yes, ma'am. But the results are still awaited. My lord, I have taken dusty.
How does it matter? Is it okay?
My lord,
Or you file it with the registry?
no, I filed the affidavit. It's not on day or not.
Oh. Okay, right. Mr. S.P. Sharma, Learned Counsel for the petitioner, appears and submits that. In terms of the order dated 4/3/2025, the petitioner has participated in the interview for filling up the vacant post of Assistant Professor, Department of Anatomy, AIMS, Guwahati. That's all. He also submits that. Notice by way of justice service has been effected upon respondent number 7. Yes, who is appearing for the other side? Yes. What is to be done now? Date can be fixed for what? I'm not aware of what the case is all about. Basically, we have to file an affidavit. With regard to, you see, he wanted to take part in the interview. Yes, sir. You were not giving him permission. You had rejected his application. Now the issue is, if he's selected, whether you can stop him from going, or whether you could have stopped him from going to the interview. Mr. A. Chaliha, appearing for the health department, is granted how much time? Is granted 10 days time to obtain instructions and file affidavit with regard to whether the petitioner could have been debarred, whether the petitioner's application to allow him to participate in the interview could be barred, could have been rejected by the respondent. And the further question would also be as to whether the petitioner can be barred from leaving the organization if he is successful in the interview. This is the matter after 10 days.
Steps